All right. Hear ye, Court of Appeals of the State of Michigan is now in session. The Honorable Kathleen A. Feeney, the Honorable Miriam Saad Bazi, and presiding, the Honorable James Robert Redford. All persons having business herein draw near, give attention, and they shall be heard. As say the United States, State of Michigan. And so.
Thank you. Please be seated. And now Judge Feeney. Sorry, Kathleen, we should have waited.
Get my rules in.
I hit the button too fast. Kathleen, please be seated. Kathleen and I was so lucky for 12 years in the Kent Circuit Court. Kathleen and I were one floor either above or below each other. And whenever we'd have questions about the respective areas or various dockets, had an influence on one another's go running down the stairway. So Kath, I'm really sorry for that.
That's okay. No problem. Usually it takes 2 seconds, but I'm like, I can't make
She's
this
so
work.
fast. I'm
I
like,
can't make this
I'm
work.
usually waiting for her, so.
I
All right.
apologize.
Well, good morning, everyone. Okay, now, I know you're all mainly appellate lawyers, but some of you are trial lawyers, and when you picked a jury and that's the response you got from us 3 circuit judges, what we would then say again, now, let's try that again, ladies and gentlemen. Good morning.
Good morning.
All right, excellent. Thank you. I'm Jim Redford. It's my privilege to serve today with my very dear friends and colleagues, Judge Feeney and Judge Bazzi. This is the second time I've already had a chance to serve with Judge Bazzi, and Judge Feeney and I have sat together a bunch of times. So this is as y'all are, I'm sure aware, because almost all of you are, regular customers for the Court of Appeals. It's an unusual docket for us this month. 7 cases for the entire month, which is what it is rare, but it's because they are called box cases. And I'm going to talk a little bit about that so that you understand sort of the level of granularity that we've already been able to achieve for your respective cases. None of these cases went to research. All of these cases went directly to chambers. So every one of these cases has had a research memorandum thoroughly prepared by our senior law clerks. So these are lawyers who have already been either in private practice or with the court or research attorneys or previous judicial clerks. So we've had very, very fine lawyers take the first cut on it. The 3 of us were talking before. I've had the privilege of being here 7 years. I've never had a case call where the 3 judges communicated so much about all of the cases. It hasn't happened before. The reason that's important for what we do next is, as I also said in there, when you start your oral representation and presentation to us, you do not have to start in the book of Genesis that in the beginning they created light. Okay, so we really have gone through it. Many of your cases have been to this court previously. We have read those previous opinions. Many of these cases have been in litigation for over a decade. We get it. Okay, so if we can go to the salient points where you think, if you're trying to get the trial court overturned, where the mistakes were, if you're defending it and trying to get it upheld, where do you think it was correct or why, given the standard of review, it shouldn't be overturned? That would, for me and my simple, trial lawyer self, that would be the most helpful part. But we've read it, we've looked at it. We're grateful that we have a lot of very, very fine lawyers and law firms with us. Thank you for the briefs and the briefs and the briefs. So there are many thousands of pages of briefs in these 7 cases. Those are my sort of introductory comments. Appreciate you being here. Judge Feeney, anything you'd like to add before we get started?
No, thank you so much for being here. Thank you for the excellent briefing. As Judge Redford said, you've really given us a lot to consider and don't feel like you need to use your whole half an hour.
Judge Bazzi?
No, again, I would just echo the same remarks. I do believe everything was briefed very well, and I appreciate all of the work and effort that has gone into that.
Okay, and I have a note that said there's some individual who has some back issues and may need to get up and move around. That is fine. I do that on a regular basis myself, not as much as an appellate judge, but as a trial judge, I did it all the time. you need to get up, you need to stretch, that's fine. I used to say, as long as you don't do the Marine Corps Daily 7 in the back of the courtroom, we should be okay. That's a whole series of calisthenics. So, all right, without further ado then, we call the first case, which is the November case call for panel 2 for the Court of Appeals of the State of Michigan is case 369572. It is a matter of Simone Morrow versus Anthony Morocco. If I mispronounced the names here or in any of them, there are 5 principal individuals and I may mispronounce the names or others will. Please accept our apologies. It's meant as no discourtesy, but we are familiar with with the case and we look forward to hearing comments. And Ms. Victor, you may proceed.
Thank you so much. May it please the court. I'm Cindy Rhodes Victor on behalf of appellants, and you pronounced the names just perfectly. Thank you so much for allowing me to present by sitting on my scooter here.
Of
I've
course.
had some injuries and surgeries and facing a leg graft at the end of the week.
Oh,
So,
gosh.
so thank you. And
Best
I'm
of
sorry
luck.
for not standing.
Oh, no, please. Thank you for being here.
Thanks.
Appreciate
Thank
it.
you. No, I appreciate it. The various panels have been very kind over. I think I've been here once a month or more, and everyone's been very kind. So thank you so much. I'd like to reserve 3 minutes for rebuttal, if I may.
Yes, ma'am.
Thank you. I've been in front of each of you on different panels before, and one thing that I can say is to echo what you said, Judge Redford, is that this panel, that each of you is always very well prepared. So I don't want to do these in the beginning, God created the world and to go forward. So I will try to pick up on just salient points. I'm one of those cases you referred to that
Yes.
has prior rulings. Twice we
Just
have
a
been-
few. Yeah.
Yes,
You
twice
know,
we have been in front of the Court of Appeals. And
I don't think the Supreme Court has formally weighed in yet. Maybe we'll get an
No, no, it
opportunity
has
in
not.
creating
It-
our
no.
paper here.
And I'm
So-
also one of the cases, if there are others who have been basically in litigation since 2011. So yeah, that would be 14 years. That would be
Yeah,
more than a
Yep.
decade.
No, Judge Marlinga is, he's run for Congress twice since,
Yes,
since he
exactly.
started on
And,
this
and
case.
thank you for pointing out, even though the front cover of ours says Jennifer Founds, she took over, the rulings were made when Judge Marlinga was the judge, the trial judge. So, so with that, we have a few points. One is that, when the Court of Appeals, in the first iteration, second iteration, when it sent it back, it said that, there was a case filed by the now defendants. They were the plaintiffs, we were the defendants. The Court of Appeals did not reinstate our counterclaim. What they did is they amended the dismissal of the counterclaim from being with prejudice, which the trial judge, which was a different trial judge than Judge Marlinga,
Right.
did at that time. They amended it to be without prejudice, requiring us to refile a case, which is why this is a 2017 case filed in front of and was assigned to Judge Marlinga. In that case, we had 3 claims, including the conversion claim that's at issue here. And when we refiled it, we added claims that had accrued since the counterclaim had been filed. And that included fraud and misrepresentation claims, and it included the breach of contract or rescission claim. There was another breach of contract claim that was in the original, but the breach of contract claim as to rescission was added. These claims were dismissed by the trial court as being barred because of compulsory joinder and or res judicata. But they could not have been brought at the time we filed the counterclaim. The counterclaim was filed in April of 2010. I'm sorry, 2011. But the case itself, these claims didn't accrue until after that. For example, the breach of rescission claim, the breach of contract rescission claim didn't accrue until June 4th, 2012. It's not that we're at this point challenging the validity of the breach of the assignment, which is the contract that's at issue here, but rather that the consideration under that assignment was never paid by the parties. It said a certain amount would be paid and it was never paid. And we brought a claim for rescission for failure to comply with the assignment language. That
Who was that payment to be made to? though?
it was to
to
be
pay
made to
Fifth
Morrow
Third.
and Jeswale and Democoria.
All right. By whom?
By the Jode Investment folks, Mr. Finelli and Mr. Morocco.
How do they not know they haven't been paid?
At that point, they thought, and thank you for that question. At that point, they believed that they were going to be part of a new entity because they had been promised that they'd be part of a new entity called Club Golf, in which they would go in and they would purchase the property and then they would be partners in and Club Golf as they were in the Burning Tree entities. It wasn't until the court ruling on June 4th, 2012, where that was clear it was not going to happen. But at that point, their counterclaim had already been dismissed, so it wasn't like they could amend their counterclaim or file a motion to amend their counterclaim to add the claim, because their counterclaim had already been dismissed and had been dismissed with prejudice, so it wasn't like it could be revived.
The final order that brings us to today was issued by Judge Fonzie.
Yes,
All right. And what does that order do?
that order dismissed without prejudice the counterclaims and a few claims that we have remaining. And we are here. The claims that we have in front of you, we think are the more salient
She-
claims.
I'm looking at a January 12th, 2024 order, and it says the following. The parties by and through their respective counsel having agreed and stipulated that the remaining claims of plaintiffs and counterclaims of defendants are to be dismissed with prejudice without cost to either party, and the court being otherwise advised in these premises, it is hereby ordered the claims of plaintiffs and the counterclaims of defendants remaining in this case are dismissed with prejudice and without cost to any of the parties. This does not affect any claims which were already dismissed in this case, which may be appealed upon entry of this final order. That's the appeal, the order, as I understand it, you're appealing from as a matter of right. Is that
That's
correct?
the final order from which we're appealing, correct?
Right.
But if
And-
we are
and-
actually appealing prior decisions.
Right. You're appealing the January 30th, 2018 order where the trial court granted summary disposition in favor of the defendants and dismissed counts 4 through 7. And you're appealing the June 6th, 2018 trial court order where the defendants cross motion for summary disposition of count 1 of the plaintiff's complaint, right?
Correct. That is correct.
What part of the unjust enrichment is covered in the January 30th or 2018 or June 6, 2018 counts?
The first order,
Mhm.
I'm going to get them backwards. It's the second order is the one in which Judge Marlinga dismissed the fraud and misrepresentation and breach of contract rescission claim.
Okay.
I think the remaining claims that we did file were for the claims that we're looking for were conversion. And these claims, these are the ones that we are appealing. The rest of them, we are not appealing.
Okay.
So with respect to the new claims that we added, were fraud and misrepresentation and breach of contract rescission. As I said, we don't believe they were, to follow that they were, they had accrued, quote, at the time of the serving of the pleading, which is what we followed from Garrett versus Washington in 314, Mishaps 36, 216. As to the conversion claims, the circuit court reasoned that because the Court of Appeals ordered compensation for personal property, that it couldn't allow any other theory of recovery. And it cited to the Court of Appeals opinion. But the actual Court of Appeals opinion doesn't say that. It says, the actual opinion said, it is important to note that this court's remedy is not dependent on reinstatement of any of the defendants, we were the defendants at that time, counterclaims. Consequently, because this court's order for Club Golf to pay defendants was not related to any of defendants' counterclaims, the issue of standing is not implicated, and it goes on from there. It was not a determination based on our counterclaim as to conversion. It was separate and different. It was an alternate remedy that this Court of Appeals fashioned to compensate my clients. But the conversion claim was never decided, wasn't decided on the merits. And we looked to both statutory and common law conversion. Statutory conversion under 600-2919A, the statute says the legislature intended to create a separate cause of action for conversion in addition to any other right or remedy a victim could obtain at common law. That's from the Supreme Court's Aroma Wines and Equipment versus Columbian Distribution Services opinion at 497 Mich. 337. And in that case, the Supreme Court examined the language of, in Department of Agriculture versus Apple Tree Marketing, 485 Mich. 1, 2010, the Michigan Supreme Court examined the language of 600-2919A and said it was a remedy, quote, in addition to any other right or remedy. And the legislator used such expansive language, it allowed the legislature then provided for cumulative remedies. So that's where we say the trial court erred in saying we only had one remedy, the remedy that the Court of Appeals fashioned, and then that barred our claim for conversion, because that goes contrary to the rulings of the Supreme Court and the Aroma Wines and the Department of Agriculture versus Apple Tree Marketing case.
Can I have you go back a moment? You were talking about the fact that the cause of action on, I believe, only came about, I think it was June 4th, 2012.
Correct.
But why is that the date? Because couldn't alternate theories of recovery occur? I mean, just because on that date is when the court said the burning tree entities were dissolved. But why couldn't you have sought relief, or why didn't the claim establish before that date?
Thank you. Because it wasn't until the burning tree entities were dissolved and my clients were not made part of the new entity. It was just dissolved and all of their rights were extinguished that they had, that the claim accrued. It wasn't until the decision of the trial court that their ownership interest didn't transfer to the new entity.
But didn't they know they weren't part of the new entity?
They did not know. I mean, they would.
So they showed up in court and on that day, on June 4th of 2012, it like all of a sudden kind of hit them like, wow, I could have had a V8.
Oh, absolutely.
We're not part of this new entity.
Oh, no, absolutely. It was, yes, exactly. And they have testified about that under oath, in other proceedings involving these parties, that's exactly what happened. And then from there, although it's not relevant here, then one of my clients, Mr. Morrow, was held in contempt for not transferring over the personal property and put in jail for it. And then this court fixed all that, but fixed that part. But yeah, they literally were taken by surprise and shock. None of those things were anticipated whatsoever.
They were in litigation, right?
They were in litigation, and
Well-
I was not their attorney at the time, I can tell you that.
Okay, but there were claims that very imprecise description. I was in business with person A, I'm person B, person A did me wrong. I mean, that was sort of the theme, right?
Correct. but they
Okay, so
were-
if that's the theme, if we know that there's a tort, because that's what the allegation is, damages are not an element that are required to be pled with specificity. An allegation of damages is enough to get the case going. Why didn't your clients have an affirmative obligation to bring whatever claims that could have been available by the nature of the relationship between A and B, and then later amend with more specificity what the exact damages were?
Thank you, because That's an excellent question because that's exactly the process. What happened was my client said, we were done wrong. You converted our property. You haven't given us an accounting. You breached your fiduciary duty. So those were the claims that they had. They didn't know about what they've claimed later to be fraud and misrepresentation until later. So they did them wrong. They just didn't know how and in what ways they did them wrong. They knew certain things had happened, but it wasn't until later events happened that they discovered, found out, realized that there were other things that had gone on, the fraud and misrepresentation and the failure to pay under the rescission contract. So those are things that were not, at the time they filed the complaint, the rescission contract wasn't even part of what they were arguing about. I mean, that came up through the agreement, the contract, the agreement to turn over their rights to redemption rights wasn't even at issue until later, until it was like, whoa, this happened. So I think there was an
The
anticipation.
redemption
they
to
were going
the
be
personal or
paid.
the real property?
The redemption rights was for the real property. The remedy that this Court of Appeals did was for the personal property.
Okay.
It said because the redemption agreement had been signed, there really wasn't anything they could do. Don't disagree with that. However, the fact that you didn't pay under it, you know, you have an agreement, it's a legit agreement, but you didn't pay your money. So you can have a legit agreement and somebody can breach it by not doing so. They didn't know about the breach until later. So yeah, bad things did happen. More bad things happened later.
Excuse me.
Is there any other questions that I can answer? I know I'm probably skipping bunches of things, but I'm trying to just hit a few salient points.
I'm good.
Okay, thank you. With that,
All
I'll
right.
reserve the rest of my time for
All right.
rebuttal.
All right. Thank you,
Thank you.
counsel. Let me just,
And with that, I'm gonna back up so Mr. McKay can have the podium.
okay. Thanks. I'll give you a moment to get that done.
You might just want to pull that microphone up by you and then we'll put it
There you
back
go.
down for a second. There you go. Thank you.
Good morning. May it please the court, Pat McKay for the appellees. I think I just want to address some things that just came up. I had all these written notes, but I think maybe I can help the court here a little bit. In the prior 2011 case, there was a conversion claim filed, which says that I just pulled up now, that Morrow and DiMercurio, by virtue of their managing membership interests in BT Investors, had and have a property right in and a right to immediate repossession of the property, personal property of BT Investors. So there was a conversion claim in the first case. They file a conversion claim in the second case. And in the second case, the court said that they can't double dip by asserting a new conversion theory for the same issue and asking for treble damages here. The court says that the Court of Appeals merged all possible theories, whether conversion, unjust enrichment, restitution, or breach of fiduciary duty into one remedy under MCR 7.216A7, meaning anything regarding the personal property assets was resolved at that time. When we went back, we did a hearing on the valuation of the personal property assets, and that issue should be dead. That's what the trial court says.
When the case went back and there's this evidentiary hearing and there's a determination that the universe of property is worth, let's say, $100.
Mhm.
Okay. I know that that's not the correct number, but let's just assume it is for purposes of this question. Once the determination is made that it's worth $100, and do we then divide it by 5 for the 5 various shareholders?
I believe it was 4
Well,
to be divided by the 4. Yes.
did the LLC that had a share, did they have two shares or just one?
So there was Joe Investments that had an interest, and then Mr. Morrow, Mr. DiMercurio, and Mr. Giswali. So there was Joe Investments had
All right,
one interest.
so it's for 25% interest.
Correct.
Is there the $100 that it's determined, does that $100 ever get split up between the 4 owners?
While there was some that ended up being garnished, which we were in front of you guys on
We're not you guys. We are the
You-
Intermediate Court of Appeals
Yes.
for the state of Michigan, second to the Supreme Court. We are either the
My
court,
apologies.
the judges, okay? I do that to everybody, every lawyer that says, hey, you guys, we're not here on the schoolyard. This is a
My
formal
apologies.
place. Please
Um,
proceed.
So we were in front of the Court of Appeals on garnishments that took place. Eventually, the entity filed for bankruptcy because it owed $700,000 based on the court's prior rulings.
What was the result of was there a formal discharge in bankruptcy of that indebtedness?
It was a circuit court bankruptcy, an ABC filing. Like,
Circuit court
right,
bankruptcy,
it-
gosh.
I didn't
did
know
you-
we could
we
do
have
that.
I usually-
Did you
No.
have that?
I would
We-
love that.
that's what
We
we
didn't
were
have that in
calling
Kent
calling it.
County.
The
Holy
assignment
cow.
for the benefit of creditors, Your
Oh,
Honor. So,
Okay, sorry.
because we
Boy,
don't,
circuit, that would have,
we don't live in the world of
that would have
bankruptcy.
made settlement conferences a
Oh, my
lot
gosh.
easier.
Right.
Oh, yes, absolutely.
Sorry, we digress.
So that case was eventually closed out and these are facts that I think are maybe not relevant to this case, but eventually Mrs. Victor's firm got all of the ask or Miss Victor's clients.
Okay, the main thing I wanted to know, counsel, was whether when it went back, is there action on the intermediate court's orders that send it back that deals with the personal property? And you answered it. So thank you.
Yes, okay, thank you. So that was the first thing I wanted to clear up. And then regarding counts 4 through 7, which were the fraud and misrepresentation. The court did not rule on C10 grounds. They ruled on C7, C8 grounds, compulsory joinder. And Ms. Victor is setting forth or trying to set forth questions of fact to get the case alive. But I think.
Why do you think the trial court was correct in those conclusions?
It's the issues and transactions at play. That there was all of those claims resolve around the consent and assignment of the redemption rights, which the Court of Appeals in 2014 said that the trial court did not err when it ordered Burning Tree Properties to meet its obligations under the assignment and quitclaim deed to title the real property over to Club Golf. So all those claims revolve around the consent and assignment of redemption rights, which they're trying to be unwound. But we have a trial court opinion and a prior Court of Appeals opinion. And the trial court again says that these matters could have been, should have been, and were actually by implication raised, although not called a fraud claim at the time. It is just a reworking of allegations that the Court of Appeals already determined. So that's why we would like the trial court
Right.
affirmed in that regard.
Okay. I have another question. In looking at our docket for Judges Bazey and Feeney, and I also was a nosy neighbor and I looked at other dockets for this month. Is there another appellate argument in the Michigan Court of Appeals involving these parties this month?
Next Thursday, Your Honor.
Why would that happen?
Any reason that the parties wouldn't have said these are related cases, or are they not related?
I believe those cases are not related cases. Those are different parties. That was,
Your sister counsel's nodding her head. It's okay, Judge
Yeah.
Redford,
Right.
you can lose your mind about other stuff, but don't lose your mind about that one. These are not connected.
Cindy and I have been involved with these cases since, like she said, 2010, 2011. Almost my entire career is involving these cases. So,
I think the world will.
Oh, God. So have you schooled them up to be, how to be a good lawyer, their counsel? Okay, all right.
You know what, honestly, that is a real benefit to your clients and to the case, because we have
Oh.
all three of us have seen cases that have gone on like this where the counsel can't even be in the same room together without coming, fisticuffs. And so that I think is a real tribute to your ability to work together as counsel, despite the length of this case.
Yes, I agree.
thank you. We have a lot of respect for each other. We treat each other well. So,
Good, as it should be. Judge Bazey, any questions?
I don't have anything.
All right,
Thank you.
thank you, counsel.
thank you.
Could you adjust the microphone for Sister Council just to? Like we're at Ford Field with the directional mic, so we'll now hear the referee's call. Okay.
Thank you again for your kind words. I agree with you. I do not think that that is the way that people should act toward each other and respect Mr. McKay very much. With respect to the arguments, with respect to the conversion claim, the fraud and misrepresentation claims, Mr. McKay was right that all of this comes from the issue of the breach, the assignment agreement, the assignment of the redemption rights. I'm not here saying that that agreement was improper, that the Court of Appeals in 2014 made a mistake. I'm saying once the Court of Appeals in 2014 validated the assignment agreement, we needed to be paid and we haven't been paid. The consideration that that agreement has says we are to be paid X dollars and none of it was ever paid. And we want to either be paid or have the contract rescinded for lack of payment. Just that's where it comes from. I agree that the Court of Appeals in 2014 said that that transferred the title. And the same thing, it was June 4th, 2012, when the circuit court ruled that. So we want to be paid under that agreement. And that's where that comes from. So I've done backwards. That's the fraudulent and breach of contract claims, fraudulent extortion, breach of contract. With respect to the conversion claim, this court did this, different panel of this court did fashion a remedy, but it specifically said from the quotation that I read to you that it was not ruling on what were then counterclaims. It was fashioning its own separate remedy. It didn't extinguish our counterclaims. It didn't say we're wiping them out. In fact, it changed the dismissal with prejudice to one without prejudice, giving us a right to file it. If the Court of Appeals believed that the breach of contract claim and the conversion claim and other claims that we had were subsumed in its remedy, it would have said so, and it would not have changed it to without prejudice, allowing us to refile the conversion claim, which we did. And the statute and the opinions that I referred to in my first argument allow for cumulative remedies. And that's what we're seeking, that the conversion's a cumulative remedy. So thank you for your time.
Okay,
this morning.
thank you both. Very well briefed and well argued. The matter is submitted. Case number 2 on today's docket. And we'll just give council a chance to clear.
I will be out of
Thank you
here.
both. No, just
Thank
take
you
your
so
time.
much. And thank you to the court for my accommodation and to your wonderful staff.
Our staff is
They are the best.
aces. They are definitely the best.
Thank you. I have always been treated with such kindness since I've been in this situation.
Oh.
I know exactly. Thank you.
All right, the next matter is the matter of the estate of Mary T. Cyron versus Ford Motor Company. It's case 371722. Look forward to hearing oral argument. We're familiar with the facts of the case. It's a tragic and sad case, and look forward to hearing what the positions are of the parties. Thank you.
Good morning, Your Honors. Robert Sauce, and I'm here with my co-counsel, Richard Denny, and the client as well is here with his wife. And I'm going to let Mr. Denny do the arguments.
Thank you.
Good morning, Your Honors.
Morning.
I am one of those trial lawyers and not an appellate lawyer, but I'm very familiar with rollaway cases, which is what this is, and that's why I'm here. Rollaways, as you all know from the reading of the briefs, are one of the most common risks in the industry. Going back 50 years, we had emergency brakes because park brakes and even manual transmissions would slip out sometimes or would come for a variety of reasons, mechanical reasons, driver failure, a variety of reasons, and alternative systems to hold the vehicle still have been known forever.
But isn't this a different case? I mean, because according to the information in I'll call it the the black box in the car, because that's what I assume that it is. They checked the computer and the computer said that the car had never been put into park.
There are
So-
really two responses to that, John.
Okay.
The car, as you know, went into water and firemen and various people were messing with it, and it was loaded onto the back of the trailer and carried away. And it was months before the parties could get into it and do the dual inspections together, which we do because we don't want spoliation claims, et cetera. And determine one, that it wasn't probably part of a recall, but that it looked like it never came out of drive. Number of the incidents we recited in our briefs were drivers like this one, like Mr. Siren told his son, there at the scene that day, thought they put it in park. And it wasn't in park, it was in drive. And this vehicle, because when he stepped out of it, did not move.
But didn't the warning, the car was meant for the warning light, the ding, ding, ding to
That's
go
the-
off? And
Absolutely. the
and a
gravity.
flashing on the, I'm losing my
It's not
words.
flashing. Your
Dashboard.
Honor.
Dashboard, thank you very much. I knew
It's-
it began with a D.
It's flashing up. It's not flashing. And here's the problem with that, Your Honor. As you all know, I'm sure, and you've read this in the briefs from the expert testimony, the hierarchy for engineers is safety comes first. And as things evolved with these kinds of problems, two remedies were, the car companies came up with two very effective remedies. One of which was a simple system where the electronic brake, and this was an electronic brake, simply applied the park brake if you opened the door to get out of the car, took your seatbelt off. And therefore, whether you put it in park or not, it ain't going anywhere. The other one was a shift to park, which is more complicated. It's more of a guarding system where it shifted the shift mechanism to park. This company used both in the MKZ on the same platform in the same year, which is basically a dressed up version of this car, and used it for no other definable reason, but exactly what happened here. If a driver stepped out and for whatever reason, it didn't get out of drive, it never got into park. And in the discovery, we discovered that, and we discovered that we're talking about a change in the algorithm for the automatic park brake. It's a change in the algorithm in the CPU and adding a simple sensor. We're talking about cents or dollars.
But is that required to protect against every single foreseeable misuse of the vehicle, I suppose? And I understand, I think ultimately the experts have testified that those types of services were available in less than 10% of vehicles on the road.
The testimony was that in the evolution into electronic brakes and the evolution into electronic shift systems, which have now occurred over time, but it happened at this manufacturer with that platform were happening 4 or 5 years before this car was built. In that evolution, the design to make the park brake set itself automatically came about. It is that last of those things. The first thing is design, the last is warn. The warning that Her Honor asked me about here is on a dash, and when you turn to get out of your car, you're not looking at it. And that's the testimony.
I thought there was also the audible.
Which
Warning.
unfortunately is the same audible you hear if you open your door and step out with your keys or without your keys. Exactly the same audible, even though you may have put it in park. And so you don't have anything to distinguish. That's the testimony. You don't know that it's any different. And so you're not alerted. And then we go back to that engineering hierarchy that our experts testified to. Design first. What's the design? An automatic park brake or shift to park. Guard second. You can argue that a shift to park is a mechanical thing. It might be considered a guard. That's a little esoteric, but you can make that argument. The last of those is warn. That's the last thing you do in the hierarchy.
But again, to Judge Bazey's question, wasn't the evidence that only 10% of the cars on the road at the time of the accident had those systems in place?
10% of the numbers of cars, Your Honor, in a survey. Think about that for a second. It's not models. It's numbers of cars. Some manufacturers were much slower to adopt electronic brakes and electronic shift mechanisms than others who generated lots and lots of cars and lots of models. But Ford and GM and Chrysler and Jaguar were on this starting in way back before 2019 when this car was built. And they were in fact on it as early as 2014. And in this particular model of car, they recognized and they admitted in their, when I took the design engineer's designated deposition, the 30B6, for lack of a better word, admitted there was a known risk and admitted that the sole purpose of this electronic brake shift that is to prevent this very thing. It's not adopting every safety mechanism for every foreseeable thing. It's for that thing. It's for rollover, roll away. Sorry. It is to prevent rollaway. That's the sole purpose of it. There's no other purpose. So you make this algorithm change, put this little sensor in, or you go shift to park if you're electronic shifter for that purpose and no other, because you've had over 1,600 incidents, some with injuries and deaths.
Again, but those were the park ones,
No.
not the put in the drive, I thought.
Not necessarily.
Well, but maybe I misread the statements then, because the vast majority of the rollaways, as you're talking about them, are the into park, something happens, the car moves, as opposed to into drive, you thought it was into park and something happens.
I suppose if you took it numbers because of the recall, you may recall, Your Honor, that there were thousands involved in the recall.
But this car was not one of
But
them.
this wasn't one of them. But if you took the numbers of rollaways where it was in park and rolled away because of the recall, absolutely, the vast majority of it was in park and the recall let it happen. Or it didn't ever get in park because of the recall. Remind you that it sometimes didn't get in park because of the recall. But there were a significant number of them that were driver error, misadjustment, the failure of it when you push the button, of the button to be effective, you have to push the button and move the shifter forward.
Which the picture when the car came out of the water showed that it wasn't all the way forward. It was still in drive.
Exactly. It never got all the way forward and the button never, when you push the button and go forward, it actually moves into a, for lack of a better word, a notch, mechanical notch. And so what you got going on here is a known, and this is the most important thing about what I believe the judge's mistake was. He made a ruling this is a foreseeable misuse, which is not a defense under Michigan products liability law. If it's unforeseeable, it's certainly a defense. Foreseeable misuses, assuming you can design around them or guard or warn, you must address in that hierarchy. That's what engineers are always told and are taught. And that's the best practice, is to design first. They didn't design first. And so you got a man who's testified, he believed he put it in park. Or hadn't testified, he told his son. He's unfortunately deceased. And he died thinking he may have killed his wife and daughter if he didn't get it into park for whatever reason. But you got all these incidents where for a variety of reasons this happens, and then you've got the fix. 4 years before this, you got the fix. Very simple fix and inexpensive fix.
But you said there was the MKZ where it was the only vehicle that they had on the line that had that fix, correct?
The vehicle in that platform that had it was the NKC. Ford had other vehicles that had. So did GM, so did Jaguar, so did.
How many other
Chrysler.
vehicles were on that same platform?
On the MKZ platform?
Yes.
I think there's only 3.
So it was the MKZ, the Explorer and
This one.
I thought this was the Explorer.
No, it's
No, this
Escape.
Oh,
vehicle.
sorry.
It's smaller. I think it's.
This is
Escape.
a smaller, it's a little
Escape.
smaller than.
Okay,
Explorer,
sorry.
Fords are all
The E,
Right.
that's right,
Expedition.
that's right. Sorry about that.
Escape, so forth.
Exploder.
Yeah.
Yeah, I think, Your Honor, and to hold me to this, it's not part of the record here that I've reviewed recently. I think there's 3 models
Okay.
at that point that
But
went
there's no
to.
requirement also for the company to put the same fixes on all of their vehicles.
There's
that same
no
platform.
minimum requirement set by the National Highway Traffic Safety Administration that requires that. We're talking basic engineering here, engineering 101. Which comes first? Safety? Of course. If it's effective, if it's feasible, if it's technologically feasible or economically feasible, both of which these fixes are, absolutely. No question.
But ultimately, this vehicle was in compliance with all the standard safety protocols and procedures, correct?
Exactly. This vehicle did not comply with engineering 101. I mean, our expert testified to that, and Mr. Fye admitted it, as did, as you know, we cited the defense 30B6 witness in our submitted matters with this court.
But it was in compliance with the relevant safety standards that were out there. It didn't have this additional mechanism that you're requesting, but it was in compliance with all the relevant safety
It
standards.
would have met the minimum standards of the National Highway Traffic Safety Administration, which I'll remind the court are minimum standards, which has never been the law in Michigan. The law here is where it's unreasonably dangerous, and a lot of vehicles can meet a minimum standard and be unreasonably dangerous, because for one thing, the standards just don't cover everything. As evolution happens, as did here, the standards don't cover a lot of things. Rear seat belt airbags, rear seat airbags, for instance, or side curtain airbags, or a lot of other things don't get picked up in the standards because of the legislation just not happening. And so what often happens is we see defects that come up. Example, your honors probably remember reading about, like the Takata airbags that blew shrapnels into everybody. There's no standard for shrapnels coming out of an airbag. Absolutely no standard that addresses that. But when something like that starts happening and there's an easy design fix, which they knew about, and here they knew about it, and they had an easy design fix.
But in your example, there's a defect, there's something in the vehicle that's causing more injury as it's going. So the airbags are coming out, there's shrapnel coming out, it's causing additional injury. Here, you're indicating the car was performing the way it should have performed based on industry standards. It wasn't making things less safe. It simply didn't have an additional mechanism that would have protected against user error. And this, I mean, leaving the car in drive as you get out of the vehicle, again, this is tragic. I don't want to make light of what happened. It is incredibly sad circumstances, but the user, when they step out of vehicle, should also make sure the vehicle is in park.
And that's why Mr. Styron's statement is so critical, and why the officers in this case, when they were examined in their depositions, and the experts addressed the fact that the officer found that the vehicle was attempted to be put in park. And because when you go back and look at some of the specific citations we have of incidents that Ford reported in their own records before this, a lot of drivers thought they put it in park and it didn't go for whatever reason. And there's a variety of reasons that might not happen. That include mechanical issues or this recall issue or various things that can happen, adjustment issues even, and things like that. So unfortunately, we have a vehicle that's submerged, drug out of the water, that sits for months, and we don't know who moved what, and no one ever will.
But wasn't there, counsel, a digital memorialization of the events that took place with the vehicle before it stopped moving on its own, or being operated by someone?
There's no question that the last recorded shift, well, the electronic thing just records if it shifts,
Okay.
it was in drive when he pulled in the parking area. He had put it in drive and he pulled in there. And by the way, in the briefs, they brought up this issue where he parked it not being in a specific parking space. He's right in between the parking spaces on ground level enough that it doesn't roll away when he gets out of it.
Right. And I thought I saw something that there was maybe even a slight dip.
There was.
Yeah.
It wouldn't roll immediately. And this is conjecture, Your Honor. We left the air conditioner running. When an air conditioner comes on, it wraps up the RPMs. And
But as far as the digital signature of what happened to the mechanical aspects of the entire vehicle, of the engine, of the transmission, the last recorded event is in drive. Is that
which
fair?
is why the misuse case being foreseeable is so important, Your Honor, because let's assume that he never put it in park. It is a
Yes.
totally foreseeable misuse for which they had a design change to absolutely eliminate the possibility. An ineffective warning will not always eliminate the possibility. This design change, even the defense witnesses have admitted 100% this accident never happens with an electronic brake system that locks that brake when you open that door. 100% it never happens with shift to park when you open that door. They are totally effective design changes. Many warnings are not. As our expert testified, this one is not, because you're looking away from it, and the chime is no different. And so one of the jury questions that I set out in my brief is this an effective warning? Should he have heard or seen it? You know, that's a jury question here. Is it unreasonably dangerous not to use a perfect fix that would always eliminate it and to use a warning, even if that's the minimum standard to have a warning? And the Michigan law has never been that compliance with NHTSA standard relieves you. It does create, as you know, a rebuttable presumption, but we met that demand. We can rebut their assumption that this warning is adequate.
I'm
And
sorry, you can rebut this presumption that what?
The warning was
that the
adequate.
warning is adequate.
Thank you.
And when the court ruled this is a foreseeable misuse, that should have been the end of it. The other principal pleadings issue here that I think is critical in this case is if you look specifically at their language, the defendant's language when they filed their motion, and it's very, very important what they asked the court to do, exactly what they asked the court to do. They specifically asked the court to make one of four rulings. They asked the court to address whether the misuse was foreseeable, was there a misuse, whether the cap should be lifted because of their prior knowledge, which they had hundreds of incidents, of course, and whether or not, based on the evidence, the warning was adequate. There's no evidence it wasn't adequate, all of which was met. They never asked this court to address the primary issue. Is it unreasonably dangerous for rollaways to be common for a variety of reasons, and you have an absolute fix and you don't adopt it, but you adopt it in a sister vehicle on the same platform, which is only cosmetically different?
What year was the change that you believe should have been done to the platform your clients were in? What year was it changed with the Lincoln, the sister vehicle?
14,
So 5 years earlier.
yes.
So if you had a 2014 Lincoln,
You
looks
don't get
like,
it.
acts like, same thing, it stops when you get out of it.
We are never here. We're never here. And his specific statement to his son was, I put the car in park, I walked around the back, I went into the house, condo to gather up some laundry. It couldn't have been there more than a couple of minutes, came back and the car was in the pond. I can't understand.
How is that admissible?
Pardon?
How is that admissible?
It's a spontaneous statement by a witness who's not available in court, which is clearly hearsay, but it's one of the exceptions, Your Honor. It's an excited utterance at the scene,
Okay, excited.
Literally. at the scene that day. And there's no motive for him to say that to his son other than that's what happened to him. And there's just simply no reason for him to say that. And I set out for the court a little bit a minute ago, specifically what the defendant was asking for in their motion. And they never addressed the primary defect claim. The failure to adopt this safety mechanism for a known risk. For whatever reason, even though they adopted it in the sister vehicle and many other vehicles. And other vehicles had adopted it. In fact, I believe it's a Rodriguez case I cited in my brief that says, you know, you're charged as an automobile manufacturer with the basic knowledge of the other manufacturers. It's not enough to come in and say, oh, but Jaguar is doing it. We're not Jaguar. You're charged with the kind of basic information that, and the reason for this is obvious. Your Honor brought it up. The reporting to NHTSA, the requirement to meet certain minimum requirements, that everybody has to report to NHTSA incidents, et cetera, et cetera, et cetera. They're aware of and they benchmark vehicles and they know what each other is doing. So they're charged with that knowledge, and charged with that knowledge. The question for this jury is it unreasonable not to adopt these safety mechanisms in this platform where there's virtually nothing but a design change that involves a computer program? Literally, a CPU is reset to set the park brake when you open the door.
Much. And was there evidence with respect to the cost of that? I mean,
When I
the
asked-
Lincoln versus the Escape or the Explorer, those are differently priced.
When I put that to their design witness, their 30B6 witness, and I apologize for continuing to use the federal designation, but
I'm
it's just
familiar
how I
with, I'm
think of
familiar
it.
with that set of
I
rules.
just think of it that way. His answer was, I can't tell you exactly, something to that effect. not very expensive. And he finally admitted it was in fact a programming change with a sensor. It's
So
been
the sensor's
electric-
obviously a
electric
mechanical
sensor.
device of some sort
A
that
little
has to be placed.
little electronic sensor that
Yeah.
senses if it's not in park. And we're talking cents here and some wire, you know.
Okay.
And you're certainly talking less than a few dollars. And now the shift to park, I won't kid y'all. When you go to an electronic shift mechanism, you're going to spend some money in that design process. But remember that they had already done that design process on the MKZ. They weren't spending new money on this vehicle in
So are the
2019.
MKZ's transmissions different than the transmissions for
It's
the?
an electronic shift with an electronic shift to park. It actually, if you open the door, would shift it to park if you didn't electronically. But it mechanically shifts the transmission, if you understand what I'm saying.
Yes,
It tells it to, and it doesn't.
right.
And rather than you shifted a lever and it moved a lever, you know what I mean?
Yep.
In other words, it moves the lever down by the transmission electronically. That's the difference. And that, I mean, I'd be lying to you if I didn't tell you that's going to cost some dollars. Probably less than 100, but it's going to cost some dollars, you know.
Everything costs more.
But reprogramming a CPU and a little sensor, we're talking cents. We're not talking dollars.
Understand.
And so I guess the question for this court to decide is, one, did the judge address the primary defect? And if you read the plain language, we attached his entire logic in his order. He never did. And secondarily, the question is, are there jury questions remaining? Is it unreasonably dangerous for them not to adopt these two changes? Of course, and I set out in my brief, you know, some of the things that create questions for the jury, like did they have a duty to implement it in the 2019 Ford safety measures to prevent unintended movement on driver exit for whatever reason? Did they have economically and technologically feasible safety measures that would have prevented this accident? Of course, 100%. They admitted that. Never happens. Did they have the technological capability of implementing a better warning? Yes, my expert made that very clear. And had they failed to implement the above stated safety measure warning system, despite actual knowledge that unintended movement happened for whatever reason, and there were injuries and deaths. So we're not talking about, you know, somebody's radio doesn't work. We're talking about somebody gets run over or gets knocked down or gets killed or dies in a pond or goes off a cliff or whatever. Horrible things happen in these things because when a 3,000-pound car meets a 150-pound person, somebody gets hurt. And so that's the kind of thing we're dealing with in this case. And those are the questions the court did not address in its order that I think are the jury questions in this case. And I think the clear reading of the the Michigan law on what is a product defect requires them to look at what they had notice of was happening out there in the last paragraph of that section.
Okay.
And they clearly did not with the escape, but did with the MKC.
Thank you, counsel. Any more questions for counsel? All right. You've got,
I'd like to reserve any time I have.
you have 22 seconds. No, you have about 5 minutes left. So- Sorry. The PJ or the trial judge always wants to make sure that things are moving, but we've recognized every single case that's before us every single day is exceptionally important for all litigants. So if I kid around, it's not because I don't think these are enormously serious. It's just maybe an effort to try to take some of the tension out. So I apologize. Don't mean to offend anyone. Counsel, on behalf of the opposing party, you may proceed.
Good morning, Stephanie Douglas for Ford Motor Company. May it please the court.
Thank you.
This court has already addressed many of the problems with plaintiff's appeal. I will add some more. One of them is waiver. The district or the trial court found that plaintiffs didn't really take issue with Ford's description of what their claims were and how they were broken down. And plaintiff didn't take issue with that finding on appeal. Plaintiff says that Ford Motor Company didn't challenge the finding of a defect. That's not true, right? We cited the pages in the briefing, pages 12 and 13, where we said there is no defect, where we cited the presumption of non-defectiveness when we complied with standards. That went unresponded to. The trial court found the response to that waived. He said that their response to the gross negligence claim was less than a page. They cited one case that involved only whether imputed knowledge could be actual knowledge, and no response to the Honda authority that Ford had cited that said manufacturers need not design against careless drivers of an automobile. They had no cases themselves that answered the questions that the court was asking this morning, like, is it really a defect to not address every possible foreseeable misuse in a vehicle? Is it really a defect to not add safety features that aren't standard on cars or that aren't available on more than 90% of the cars that are on the road? They had none of those arguments, and they still have none of them here. So that gets through the first two issues that they've got. One, that there's something incongruous about foreseeable misuse that isn't a defect. There's nothing incongruous about that. The Honda case itself says foreseeability isn't enough. You have to go through the rest of the factors, like how certain is it to happen? We don't know that. What we have is a bunch of evidence the trial court said was irrelevant, all the information about vehicles that were supposed to be put in park. And due to a problem with the vehicle, they were not actually put in park. That is irrelevant. The fix for that is to fix the problem with the vehicle, not design a totally separate safety system that might happen to fix when a driver is negligent. That's not the
Counsel,
duty.
is there a question of fact as to what gear the automobile was in when plaintiff's decedent left the vehicle?
There is not. Plaintiffs concede.
Why do his statements, why did not the father and spouse's statements made at or near the time of a startling occurrence made while under the influence of those startling events? How is that not an admissible statement under the hearsay exception?
I have a few responses to that. One, it's not even in the summary disposition record. They didn't cite it in the briefing below. They didn't make this argument below. It wasn't attached to the motion for summary on either party or any response. We did have a motion in limine
Was the son deposed?
He was.
Did he make the statement in his deposition?
He did. And that we had a pending motion to preclude the evidence at the time the motion for summary disposition was pending on a motion in limine for it being hearsay and not an excited utterance. The court didn't need to reach it because it wasn't in the summary disposition record. The other reason the court.
Was it in the record that was before the trial court at the time?
It was not. You will not find it as an attachment to any of the motion for summary disposition briefing, the response, the reply. It's not in there. In fact, the opposite is true. Plaintiffs conceded in their briefing in the trial court that it was in drive. Their expert's opinion is it was in drive, that the shifter was in drive, the transmission was in drive. There is not a reasonable fact dispute, and the potential hearsay that Mr. Siren told his son after some amount of time that he had to decide what might have happened, it couldn't create a fact question given the download of the vehicle, the position of the vehicle, and the fact that their own expert opines that it was in drive.
Was the statement purported to have been made while everyone's still at the scene of the vehicle now being extracted from the pond? The mother and the sister are deceased. Is that when it's happening?
It is when it's
And
happening.
it's seriously your position that that would not qualify as an excited utterance under the case law that interprets that rule of evidence in the state of Michigan?
Let me clarify. It was the mother and daughter, or the mother and sister were both at the hospital, my belief is, when this happened. The son was called to the scene and the mother and sister were gone. So he went to check on them and came back at some point and talked to dad. Dad had already.
We're still within the same 24-hour period, right?
We are. I don't think
Okay.
excited utterance gets you to 24 hours.
No, I don't either, but having presided over and been assigned to 6,000 criminal matters of a felony nature and 4,000 civil ones in the 12 years I had the privilege of serving as a circuit judge, if we're talking about a couple hours,
I-
that's a
I-
tough road to hoe.
I understand. As I said before, I don't think it makes a
But your
difference.
position is it's not even an issue.
It doesn't create a material fact question because their own expert says it was in drive. And there isn't any argument that something about the car prevented Mr. Siren from putting it in park. There isn't right? This is a shift forward to park, pull back to drive, and he pulled it back to drive. There's nothing that suggests that anything about the car made him unable to get it into park. So whether he thought he did this, but actually did this, it was in drive. That's the undisputed fact. It was in drive. And so then the question became, as it was in the trial court, once you've conceded that the purported defect that can cause a rollaway in the recalls is not present in the vehicle, and that evidence is irrelevant. They say that the court should have considered it. They don't say why it was an abuse of discretion to have deemed it irrelevant. There is no authority. There isn't an argument that it's an abuse of discretion to deem all that irrelevant. And of course, it's not an abuse of discretion because those are about when a vehicle has a purported defect that you think it's in park and the vehicle prevents you from being in park. And what happened in this case is you may think it's in park, but that's driver error and the vehicle didn't prevent it. And the vehicle, the manufacturer does not have a duty under Michigan's law. And it's case after case that says the manufacturers are not insurers. They don't have absolute liability. The Prentice case describes a design defect as an epithet where something is wrong that makes a product dangerous. There was nothing wrong with this vehicle that made it dangerous.
Further counsel's argument with respect to the fact that the MKZ was for 5 years having the mere sensor piece that could be added to the car to prevent these sorts of accidents from happening. So how do you address that?
How I address that is you still need a defect, right? It's not an unreasonably dangerous vehicle to not have every possible safety defect. The testimony of Matt Thigh was that Ford put it in the Lincoln because it's a lower volume vehicle and it was a new technology. And so they put it in a lower volume vehicle to start that development. What we heard here was Ford was ahead of the game. You can't take a manufacturer who's ahead of the game in a new technology and say you were grossly negligent for not being all the way to the end, right? And so the answer is it is not unreasonably dangerous to include a safety feature in a vehicle and not include it in another if that other vehicle isn't unreasonably dangerous. And it wasn't. And plaintiffs never argued, even still really here, that it was, right? And
I have a question.
yes.
In the evolution of the airbag, do you know whether Ford or other manufacturers introduced them being the airbags into their higher end models before the sort of I'm a Chevy driver, not a Cadillac, so I'm a sort of a GM guy. Do you know?
I don't know.
Okay. Thank you.
I don't know. And again,
I don't know if it matters.
yeah, I'm not sure that it does because again, if the vehicle isn't defective, then there is no room for liability. The one other cause of action that was in front of the trial court that I think is, again, really easy to dispose of on a waiver ground is the failure to warn. The failure to warn in the trial court, the court dismissed it on 2 grounds. One, that Ford had raised the obviousness statutory defense of 600-2948 sub 2, and plaintiffs didn't respond to that. So that's a waiver in the trial court that, again, plaintiffs haven't addressed on appeal. They do on appeal cite the Owens case. That case said that a failure to warn for obviousness was limited to simple products. That has since been overruled by Michigan's adoption of the statute, which takes out the simple product requirement. So there is no liability for a failure to warn of an obvious risk, and here the risk is obvious, and plaintiffs haven't really responded to that. Does the court have any other questions?
No,
No, thank you.
Thank you.
counsel, could you address that point first? 'Cause there's no failure to warn of an obvious risk.
I did, Your Honor, earlier, and I apologize if I wasn't clear about it. Our claim has always been they should have designed around the problem.
But
With
if they
these
didn't know it was an
fixes?
obvious risk, I mean, it's an obvious risk that people will open the car door when the car is driving down the road and want to jump out. I mean, I had cases where kids were being taken to facilities, different things, and they would just open the car and out they'd go.
Well, and Your Honor has just cited one of the examples that Your Honor was asking about earlier. Do manufacturers adopt these things before the minimum standard requires it? One of them was child locks in the back seat. Another one was airbags. And
But how is that negligence or gross negligence? How is that? I mean,
well, now the gross negligence issue turns around the second part of the paragraph where they talk about the cap, where they talk about whether the manufacturer had notice of an unreasonable risk. And the court is allowed, not just the jury. In Michigan, it's a two-step process. The court can decide gross negligence under typical gross negligence standards. And I think here there's no question. When you know this is happening multiple times and you have a fix and you don't implement it, a jury can easily decide that's a conscious decision because you put it in the MKZ. You made a conscious decision designed to put it in there, and it's the only thing it does is stop this from happening. But you
What
didn't
what
do
do
it
you
in
make
this
of
car.
Sister Council's comments to the court a few moments ago that this was a lower number inventory product? It was new technology. They're trying to roll it out, see if it's working.
My first job with a lawyer was with the Honorable Mariano Paula, Chief Justice of the Oklahoma Supreme Court, rewriting the Oklahoma Evidence Code, helping him to do that as an intern. He taught me about Learned Hand's statement in the Coca-Cola case at the turn of the century that just because everybody does it right doesn't make it not a tort. And that would be my response to
but
that,
if
Your Honor,
it's-
is the fact that frequently, the Takata airbags were in 30,000 vehicles of 7 manufacturers.
My father
I
was
mean,
the chief industrial engineer for Eaton Corporation. We had airbags in our family vehicles that he drove in 1969. So
Not
I know
surprised.
about airbags. I just didn't know when Ford, GM, and everybody else introduced them. However, as to the point of a entity engaged in commerce has a technology that they want to develop, why can't they put it in a lower number of product in a universe of product lines to see if it works? Which is what counsel said Ford, she has a witness that Ford did that.
There's two reasons why. And I cited some cases that talk about this in Michigan law. When they know there is a risk of extreme injury or death. In the Hallbrook case, you know, that they keep wanting to talk about. Motorcycles can go over the speed limit. They can go too fast. You can hit a wall at 20 miles an hour. And it's an obvious thing that people can do and you can't design around it. Is exact opposite of this. This is that fits the cases I cited where the risk in a rollaway is so high. When people get run over, they die or they get crippled or the risk is not just the issue. And when you know it's happening hundreds of times, not only with you, but with other manufacturers, and you have a clear design alternative that 100% prevents it, then the question is, does an engineer have the safety obligation to do that? And does a company have a safety obligation? And the statute that defines the defect in Michigan actually says, it actually goes on to say, if they're aware of incidents, or if the evidence is they had alternative designs that are technologically and economically feasible. It
You got
addresses
about
that
2 minutes
very
left,
issue.
and I was wrong. It wasn't 69. It was between 71 and 74 when my dad had those vehicles. So
Still,
Long
I mean,
before the
but
statute, Your Honor.
your point being that, does the company have the safety obligation to implement that clear design? And where do you get that statement from? Statute, Is that from the design people? Is that from the engineering people? Or is that a case that you're citing?
No,
Because
600-29462, Your Honor, provides that in a product liability action brought against the manufacturer or seller for harm allegedly caused by a production defect, the manufacturer or seller is not liable unless the plaintiff established the product was not reasonably safe at the time, and we're talking about earlier, when they built a bunch more, the specific unit of the product left the control of the manufacturer, or the specific unit of the product left the control of the manufacturer or seller, a practical and technically feasible alternative production practice was available that would have prevented the harm. That's what it says, Your Honor.
But again, it's
Exactly.
not reasonably safe at the time. So you don't get to the second part of it because you haven't satisfied the first part of it, correct? Because it was reasonably safe at the time when it left. It met all the highway safety. I always want to say NTSB, but I know that's the wrong one. But it met all the requirements. It was not, I mean,
It
are
met
you
a
saying every?
minimum
It
requirement.
meant the minimum, but that doesn't mean that it was unreasonably or not reasonably safe, right?
I
One,
would,
1 minute to go.
I would submit, Your Honor, when you've had hundreds of incidents involving various reasons why
You have a
park
case
is
that
not
says
enough.
that in that circumstance, that means that vehicle is not reasonably safe.
Well, the statute on lifting the cap specifically refers to knowledge of the corporation. Specifically refers to knowledge that that defect issue was causing injury. And the reason I would submit to you that it specifically refers to that is that knowledge puts a duty on them to do something. They had that knowledge beginning in 2014, no question.
All right.
They
Thank
actually
you.
had it in 1980, but certainly.
All right, counsel, thank you. Thank you for your advocacy on behalf of your clients. Counsel, thank you for your advocacy on behalf of your clients. The matter is submitted.
Thank you, Your Honor.
All right.
Thank you very much.
Yep, you're welcome. Ready to keep, go to the next one? Very good.
Yeah, I'm definitely.
Good, keep going. All right. All right, next matter, it's case number 3 for our 10 o'clock docket. It is, and I'll just as a heads up, we're probably going to take a recess for about 10 minutes after this case is completed. Is my expectation. Even though we have number 4 is yet the Bishler Trust case, Norton versus Bishler is number 4. We're going to take a recess before that one. This case is Cambridge Real Estate LLC versus Cincinnati Insurance Company. There are 2 matters, matter 369018 and matter 369081. And we have one attorney appearing in 081 remotely, attorney Sherbarth. I'm looking at the screen. I see the seal of our great court. Okay, there we go. All right, Sherbarth, hope you're feeling better. Thank you for being with us. So we have 4 lawyers. If one person wants to speak for 29 minutes and 30 seconds, that's fine. If the other wants to speak for 15 and 15, that's fine. But the scoreboard says 30 minutes for each side of the V, not for each lawyer. So, and we've read everything with great interest and read it and read it and read it. So it's, anyway, please proceed.
Morning, Your Honor. Josephine DiLorenzo on behalf of defendant Cincinnati Insurance Company. Also with me at counsel table is Hillary Valentine. And as you noted, co-defendant IAQ is here online as well. We were going to split the time in half with IAQ, if that's okay with the court.
Okay, is that okay with you, counsel? On the screen?
Your Honor, that's perfectly fine. I don't anticipate taking the full 15 minutes.
Okay, you don't get to give it back. So, sorry.
And I'm happy to be as brief as possible,
No,
but I would.
and I don't want to, feel like we value our outstanding lawyers. I hope that's reflected in the questions that were already been asked. So take whatever time is necessary. You have 15 minutes that you want. Please proceed.
And I would reserve 2 minutes for rebuttal, if that's okay. Okay, so as far as plaintiff's claims against Cincinnati, we did raise several independent grounds for reversal, and I was just going to plan to focus on 2 of them, possibly 3. And I can summarize at the outset that Cincinnati should win because plaintiff's claims are barred by the release And regardless, their tortious interference claims fail as a matter of law because wanting to make sure that the asbestos in the building was properly remediated and that the tenants weren't exposed to asbestos cannot be a wrongful act or an improper interference.
Who is the, when the remediation starts, there's an event and some access is provided or undertaken for space behind drywall, which exposes the asbestos.
Correct.
Who brought in the tradesman that opened that aperture, which made that exposure?
That was the insured. And they hired the company called Demo Clean.
And the insured being,
Well, it was, I believe it was we were calling him Mike to distinguish from Sam. And I believe it was Mike, and it could have been his building. He had a building manager's or like a maintenance guy as well.
all right. So are you guys CNA or Cincinnati?
Cincinnati.
Okay, I'm falling back to my Plunkett and Cooney days. I thought you guys were CNA. All right.
You
So
can
you're
check out
Cinc-
anytime you
that-
like.
that-
but we
oh,
never leave.
nice. Okay,
Very good.
that was
I
good.
caught that.
Yeah. Okay. Right, back on task. So it was not the insurance company or the agents of the insurance company that said, you guys go open up these holes.
Oh, no,
Okay.
no. Our adjuster stopped that when they saw what was going on.
Right.
And then here we are. So, but to begin with, I was going to just say that we can end this with the release because the plaintiffs are agents of Village Plaza, so they fall under the definition of releasers in the settlement agreement, meaning that they release Cincinnati from all causes of action, whether it's tort or contract. And possibly my argument could be very short because plaintiffs conceded in both of their motion responses that they're agents of Village Plaza. And in Mike's after the fact affidavit, he again conceded that both he and Cambridge are Village Plaza's agents. Even if they didn't already concede it on multiple occasions that they were agents, the testimony and the documentary evidence, I think makes that clear. And I know you've read everything, so stop me if you've heard this before, but Sam testified that Mike, acting as Cambridge, handled all aspects of the property's operations. And Mike testified, quote, Cambridge provided everything to Village Plaza. So that's going to include management, maintenance, leasing, and development. And also, when he said that Cambridge did everything for Village Plaza, it did so at his direction. And Mike also held himself out as Village Plaza, and he acted as Village Plaza specifically with respect to this property insurance claim. He was the sole representative of Village Plaza throughout the entire claim. If you look at the claim file, which is in our appendix, Mike is identified as the insured, and he's the one Ms. Snyder communicated with the entire time.
Does it matter whether the plaintiff seems to suggest the insurance carrier told its inspector not to share information? Is that of any moment?
I think that she was just controlling the claim, how the claim was handled. She wanted to present a unified front, but I don't think she wanted it to go through her. She wanted to be in control of the information, but I think there also was a misstep where at one point she thought they got the air tests that they wanted and they didn't get them, but I don't think she did it intentionally.
Part of the release says there is a carve out for liability.
Correct.
Why does that not save the claims of the plaintiff?
It does not save the plaintiff's claims because what that meant, it's a release of claims under the liability coverage of the policy. So it's irrelevant because that clause meant that Village Plaza could still seek insurance coverage for liability claims made against it by third parties. It doesn't mean that plaintiffs as releasers can still sue Cincinnati for claims arising out of the property damage. Let's see, one of the other. Well, I also would say if you didn't think that they were releasers, it doesn't necessarily mean that they're not barred from bringing a lawsuit because the language of the release bars not only releasers, but also anyone claiming on their behalf. And that's from bringing any claims, causes of actions based on or arising directly or indirectly out of the claim. And the claim, of course, is this property loss claim. And plaintiffs are clearly seeking to reopen this property insurance damage claim. So they want to get in excess of the damages that were already paid, which was $10 million, nearly $10 million. And they're trying to bring a bad faith insurance claim is, I think, what it looks like they're doing.
Is that one of the claim causes of action?
They don't call it bad faith, but they use the term bad faith, I think, either in their briefing or in the complaint. But they're complaining about the way the insurance claim was handled, basically, and that there wasn't enough money paid for it.
How many tenants were there, individual workers at the situs of the insured property?
How
Were there
many
50 people, 100 people, 700 people?
tenants of the building?
Yeah.
That I am not sure. I think I saw a list of the tenants. It looked like maybe there were, I'm just guessing 15, 20 businesses, but I don't know how many people that
All right.
turns out being. There's a list somewhere. I think when they're showing the lost rents, that would list all the entities. Was there any other questions about the release?
No.
Okay, so the second ground that I was gonna focus on was their inability to meet the elements of the tortious interference claims. And we did challenge pretty much every element, but I was gonna specifically focus on the fact that Cincinnati had a legitimate business reason for asking that the building be vacated. And it's important to note that vacating the building is not the same thing as terminating the leases. So plaintiffs can't establish an improper motive or an interference. That HVAC system was affected, so it had to be shut down so IAQ could properly inspect it. I think if you read IAQ, I think it's how you say John Datillo, I think that's how you pronounce it. He kind of explains that testing and inspecting are different things, and to properly inspect it, that's going to involve cutting into things, and that's a potential release. So that's why they wanted the HVAC system shut down. So again, wanting to ensure that the asbestos in the building was properly remediated and that the tenants weren't exposed to asbestos, which is a known carcinogen, is a legitimate business reason, and it can't be wrongful act or an improper interference. And the second reason was preventing liability claims. They wanted to prevent liability claims based on asbestos from being filed against Village Plaza and Cincinnati. That's also a legitimate business reason. Ms. Snyder testified that at least 3 tenants did file or did retain counsel to present such claims. And plaintiffs try to downplay asbestos in their brief, but I mean, the evidence is pretty clear that they were well aware of the asbestos. Mike testified to that.
They argued, or somebody argued, that the manner in which Cincinnati was seeking to mitigate or alleviate the risk to asbestos exposure, which obviously is also potentially an exposure to carcinogens that cause mesothelioma, that they could have just done it like a floor at a time or a section at a time. And that which the insurer selected was inappropriate and was an intentional act to put them out of business. Basically, settle the claim for 10 million instead of the 60 million that you should have paid, because this was the site of a new development and you were aware of it. You should have had to pay for all the market value that was lost. What do you make of that argument?
So I would say that when Mike was asked if they got an asbestos abatement protocol from someone else that said that the asbestos could be abated without vacating the building, he said he didn't know if he had ever gotten that. And I would also say that when they were in charge of it, again, they let their contractor just cut into the asbestos without protection, without taking precautions. But as far as whether there were differences of opinions on how it should be done, I don't think that wanting to err on the side of caution to prevent asbestos exposure and litigation for that liability is an inherently wrongful act. That was a business decision. Cincinnati wanted to be in control and they wanted to make sure that it was done right. And relying on, I would also say that Mr. Datillo's testimony, he was saying, well, some things are possible. Like you could maybe do this inspection and not shut down the HVAC, but he wouldn't do that because of the danger. I know that you have all of his testimony and I don't want to read all of it to you, but he said that, so the property ventilation system, I had to learn all these terms too, but this open plenum means there's not ductwork, it's just an open space. And my understanding is that whole space has the, he called it friable asbestos. This ventilation system has friable asbestos. I did have to look up that term. I think it was discussed in probably his deposition, but it means any asbestos containing material that can just be crumbled by hand, with your hand, it turns into powder. And that's what makes it dangerous because it releases the fibers. And that's throughout the entire ceiling area. So the fact that they wanted to be cautious about this and just make absolutely sure that it wasn't going to be spread around, I don't think that can be a wrongful act. Okay, thank you.
All right, thanks. You have right around 2 minutes. So, okay, counsel, you may proceed.
Good morning, Your Honors. May it please the court. Nathan Sherbarth on behalf of IAQ Property Management. At the outset, I do want to thank you for allowing me to appear remotely. I have 2 school-age kids and they gave me COVID over the weekend and I don't want to spread that. So I
Well,
very
we're
much
awful
appreciate
glad
it.
to see you and we're awful glad to see you on a screen if you have the. So.
I feel fine.
And
I
about
feel
30
okay.
people in the
but
courtroom feel the same way, I suspect, but
I
hope you
feel
feel
okay.
better soon.
I'm here. I appreciate it. So I'll keep this relatively brief. IAQ's involvement in this is obviously a very limited. You know, they were hired by Cincinnati as an agent of Cincinnati to perform asbestos testing. They performed testing and provided recommendations. The crux of this case is tortious interference and civil conspiracy. I mean, the only causes of action against IAQ are tortious interference and civil conspiracy. And the only activities that plaintiffs attribute to IAQ are inaction. They're attempting to make a tortious interference claim out of inaction. And it's throughout the brief. It's Michael Hamame testifying repeatedly that, well, Mr. DiTillo went to the meeting with the Cincinnati representatives. Cincinnati said something, he stood silent. That's not enough to make out an intentional tort. And I think the parties can agree on that. At page 36 of their brief, I think there's a very telling quote, which is that both claims, this is from plaintiff's brief, both claims of tortious interference with a contract and tortious interference with a business expectancy necessitate proof of intentional interference causing a breach or termination. Intentional requires some affirmative act. I mean, if this were a negligence-based tort, we would have a different discussion perhaps, but this is not. They can't establish an affirmative intentional act on the part of IAQ. They point to Mr. Mentz's deposition testimony, and Mr. Mentz is one of their hired experts. But if you read Mr. Mentz's testimony closely, it does not actually establish any affirmative acts that would constitute tortious interference on the part of IAQ. It merely states that IAQ should have reported their findings to Cincinnati. They did. And that he believes that they had some sort of nebulous ethical obligation to correct statements made by Cincinnati if they disagreed with them. While I appreciate that there may be ethical considerations raised in the IICRC that he cites, he says, you know, this is a quote from page 191 of his testimony, and that is basically part of those IICRC ethics and just proper behavior. He then also admits later that IICRC does not deal with asbestos. That would be the EPA and state regulation, according to his testimony. So he's trying to impute some sort of inaction by IAQ that could somehow constitute tortious interference. But again, this is not wrongful per se, and he admits that the standards upon which he purports to rely don't actually apply to asbestos testing or remediation. So what they're left with is a lot of conjecture, a lot of Mr. Hamame Mike Hamame testifying that, for example, DeTillo never vocalized its disagreement. DeTillo stood there mute, so he accepted what Cincinnati was delivering. And even accepting these allegations as true, this just does not amount to intentional interference or a per se wrongful act, an affirmative act that would constitute tortious interference with contractual relationship or business expectancy or relationship. I think the sister counsel did a good job of addressing the release arguments, and I won't repeat those here. But really, this comes down to IAQ had limited involvement here. They came out, they did their assessment, they provided recommendations. Plaintiff's own expert agrees with those recommendations, agrees with their assessment. Mr. Menz repeatedly testified that he has no issue with how IAQ assessed this situation. It's essentially trying to make a claim for an intentional tort out of inaction, and that's just not supported under Michigan law. I'm happy to answer any questions. Otherwise, I'll rest on our briefs.
I don't have anything.
Judge.
No.
No questions. Thank you.
Thank you.
Gosh. Season with allergies.
Morning. I think
It's
it's
every
morning.
season.
I believe it's morning.
I think it still is.
Yeah.
It still is. Okay,
indeed.
great. Beth Whitman appearing on behalf of the plaintiffs. I have Mr. Elder and Ms. Corpus who are here in the courtroom today, those trial counsel. I also have my son here today.
Oh,
It is
wow.
election day. He does not have school, so I
Okay,
brought
where's your
him.
son? All right. Well, your mom is a great lawyer and you should listen to everything she says. And when you're wondering, just pretend that she's one of these great judges to my right or my left and she has a black robe on and it's an order that you obey what she has to say.
He
Okay?
knows.
All right, good. Ms. Whitman, you may send your
Okay.
retainer letter to me later.
Excellent.
And,
Thank you very much. I
Best of luck.
appreciate that.
You know, you should be very proud of your mother, young man. So go ahead, Mr. Whitman.
Thank you.
Ms. Whitman.
Thank you very much. That's very kind. I really appreciate it. I'm going to start maybe backwards. I'm going to start with what IAQ's attorney had started with. Indicating here that there's more of a lack of intent with respect to IAQ and that the evidence doesn't establish that there was affirmative acts, there were only nonfeasance. You know, here we have IAQ that's essentially normalizing or perpetuating this false narrative that Cincinnati is.
What's the false narrative?
The false narrative that they have to shut down the building, that they have to winterize the building, that they have to remove all the tenants, they have to evacuate everyone before they can even do anything. That includes any asbestos testing, any remediation projects whatsoever. In fact, even come up with protocols for how that's even going to happen. And that's not the case. We have expert testimony from Mr. Menz that that's not in fact what has to be done. They can shut down the HVAC overnight even, or for a day, or for a weekend. It does not.
You're dealing with this, a known carcinogen.
Sure.
That there is literally tens of thousands of lawsuits have been filed and won by individuals in particularly the skilled trades, in the heavy industrial skilled trades and shipbuilding and pipe fitting over the decades. The untold number of companies that manufactured this have been bankrupted. There's an asbestos trust fund that pays the settlements now. How can a cautious approach to something that has resulted in billions upon billions of dollars of judgments, how can that be a tort in and of itself? Or a breach of contract?
A breach of contract here because the breach of contract or the tortious interference with this is there's the contract that's between Cambridge and Mr. Hamame. And
Not the plaintiff,
and with
another Mr. Kamami.
correct, Michael Hamame.
Right.
And with Village Plaza. That's the contract that's at issue here. That contract, there's, you know, tenants that are in the building, the management contract with respect to, you know, they're going to obtain Cambridge, my client is going to obtain funds or payment from those tenants. They're going to receive a fraction of that. And there's also that development contract that's in effect as well.
Oh, there's a development concept. There's not a development contract.
There is
That's-
development contract. It is in the
That's been
record.
approved and that you've got the permits and everything and the funding and
I-
everything's good to go.
I don't know
for-
that that's the case. I know that they had been approved for, going forward with that. Yes, there were
By whom?
by the county or the city,
There
whoever they
is
needed
in
to.
the record, there is a building permit.
I don't believe that there is a building permit in the
Okay,
record.
what is there in the record that memorializes this is something other than a plan?
Well, they do have their development contract and there is
Tell me
testimony
what
from
that contract, who's the contract?
the
between?
contracts again between Cambridge, Mr. Michael Hamame and Sam Hamame Village.
Okay, why
Plaza.
doesn't Cambridge sue Sam?
Because Sam didn't interfere with the contract. There was
Sam
no,
released everybody and said, I'm satisfied. Isn't the claim, shouldn't it be against Sam?
no, because the Sam didn't require all of the tenants to leave the building. Sam didn't do nothing with the
Sam
building.
released, if what you say is true, if Cincinnati required or
Mhm.
their agents required everybody to leave the building,
Correct.
Sam, and I don't mean to be pejorative, but you've referred to him and the parties have referred to the parties by their first names. The owner of the building
Mhm.
released them and said, okay, I'll take 9 million plus the million I've already gotten.
Right,
We're all done.
right. But
How
that doesn't.
does that not end everything?
But that doesn't provide, that still doesn't solve the problem or address the question of how it was that Cincinnati interfered with that connection that Cambridge had with Village Plaza.
So what?
But
It's been released.
it hasn't,
They waived everything but the
Not-
American flag.
no, not with respect to Cambridge. They had no ability to release anything with respect to Cambridge. There's-
How does Cambridge, if they're the agent of the principal, which they are, right?
They're not.
Oh, they're
They are an
not.
independent contractor, and that's made clear in the
But-
contracts themselves.
Council. The case law of Michigan is replete with independent contractors being agents of principal. You agree with that proposition?
But that's not the case that we have here. This is a management agreement that Cambridge is managing this entity, this Village Plaza. It's developing Village Plaza. That's what it's designed to do. There is nothing in these contracts that gives Village Plaza the ability to bind Cambridge. The opposite is true. Cambridge can certainly bind Village Plaza to contracts, but the same is not the case with respect to Village Plaza's ability to bind Cambridge. There is nothing in the contracts that says that they have that ability. There's also nothing in the plain language of that release that says that in fact, Cambridge would be subject to this. It does not say independent
That all
contractors.
presupposes that everyone concludes as a matter of law that Cambridge is not the agent of Village Plaza.
Correct.
And if in fact Cambridge is the agent of Village Plaza, this release applies to them.
If they would be considered an agent, then yes.
Okay.
Then it would be. Because it says that they're an agent. It says it applies to all agents. But the other thing I think Your Honor had indicated too is that there is in fact that carve out for the liability portion of it. That allowed business interference claims to go forward from
But
these
that-
tenants.
How is that carve out not specific as to if the tenants, for example, because their employees are exposed to asbestos and maybe they get mesothelioma, I can never able to pronounce that word. Isn't it protecting Plaza from Cincinnati is still required to defend and pay on those claims?
But what we have here in this case,
No, that's the first question.
first question. Is, so the,
So I work for one of the tenants of Plaza.
right,
I'm exposed to asbestos.
Mhm.
I retain counsel and sue. That release that Cincinnati and Village signed
mhm,
still requires Cincinnati to provide Village a defense and to pay damages.
That's correct. Yes, that's my
Okay.
understanding as well. Yes.
So why do you think it also applies to Cambridge?
Because what we have here is we have in the record, the 2021 release, which shows it demonstrates that tenants within the Village Plaza who brought tortious business interference claims against Cincinnati. Those were allowed to go forward. Those were not precluded by the release. And that's exactly what Cambridge is bringing here too. And in that 2021 release, it is specifically carved out of that release, Cambridge's claims. It says Cambridge's claims that they have ongoing are not affected by this 2021 the release and settlement agreement. So we know exactly what types of claims were brought after this. And it was in fact business interference claims that were brought by tenants. And that would also include the business interference claims that are brought by Cambridge as well. I know we've hopped around a little bit too. Okay, so back to my point with respect to IAQ. So this is perpetuating what Ms. Snyder is saying, that all clients have to be, or I'm sorry, all tenants have to be removed. The building has to be evacuated before we can do anything. In fact, there's an email from Ms. Snyder to the IAQ person, Mr. Tillo, I believe is his name, that says specifically, we're having this meeting with Cambridge or Village Plaza representatives, and I don't want you to tell them anything else other than what I'm saying. I don't want you to tell them about other ideas or.
What does IAQ work for?
IAQ works for, well, they're being paid out of the insurance proceeds that, is being paid by Village Plaza.
Did they enter into a contract with Village Plaza?
Not that I'm
Did they
aware of,
enter
no.
into a contract with Cambridge?
Not that I'm
Did they
aware of,
enter
no.
into a contract with any of the named owners or LLC members of either Cambridge or Village
Village
Plaza?
Plaza, not that I'm aware of.
They did in fact enter into a signed contract with Cincinnati, right?
They did. To
Okay.
my knowledge, that is correct. But the problem is that we have expert testimony that says specifically, the IAQ cannot do this, that this is unethical, that this is improper for them to do this, to say, you know what, I don't agree with what you are saying, insurance company, but I'm not going to say anything to the insured. So we have expert testimony that specifically addresses that question. And it says, you can't do this. You have an.
But that is an inaction.
But it said,
correct?
he said, you have an affirmative duty to speak up and you have to say, I don't agree with this. This is not correct. And even besides this dynamic between Ms. Snyder and Mr. Donatillo, there is also testimony from Michael Hamame that says specifically IAQ said you have to leave this building. Now IAQ denies that, but we're here on a C10 motion. That's just a question of fact. That would then lead to a question of fact. So regardless of whether or not there is anything that the expert said or anything that would be deemed just, non-active, that just a malfeasance, you still have testimony from my client that indicates that this was in fact affirmatively stated that he had to, or that Village Plaza had to remove these individuals, all the tenants from the building before anything could happen. Okay.
Is it your position that, and I'm going to go back to the whole agency piece,
Yes.
that you can be an independent contractor but you can't be an agent if you're an independent contractor?
I think under maybe certain circumstances you can be, but it's clear under this contract that they signed that
They being,
Cambridge is the manager of Village Plaza.
So the son and the dad, the contract that
Yeah.
they signed together.
Correct.
Where the son does everything
Everything.
for the dad's company.
Yes,
He's not the dad's agent.
he is not the dad's agent.
Okay.
No,
because
he is not.
Because he says he's. not.
Yeah, because he says he's not.
So
No.
no
no.
matter what I do, no matter how I look, no matter, as a duck hunter, if it looks like a duck, if it swims like a duck, if it flies like a duck, if it quacks like a duck, it's probably a duck. So in this case, even if he signs every contract for his
Mhm.
dad through his position as a member of the LLC or the
Mhm.
corporation, he negotiates everything. He controls all the books. He does all the
pays
bank
himself.
deposits. He pays himself. He
Mhm.
decides how much he's going to get.
Mhm.
He does all of those things. Because I say I am not your agent, he is not his agent.
Because there is nothing in those contracts that indicates that he can be bound by anything that Village Plaza does. That's correct.
He binds Village Plaza every single day.
He binds Village Plaza, but Village Plaza does not bind him. Village
The
Plaza, there
release
is
says
nothing.
I release this by signing this and accepting this 9 million plus the million I've already received. It doesn't, I'm paraphrasing the
Correct,
money
yeah.
part.
Mhm.
I release any and all claims I have, as well as those of agents, et cetera, et cetera, et cetera.
Mm-hmm.
How is the son not the agent of the dad in the person, legal person of the business entity, the LLC or the corporate entity?
Yeah, I mean, the contract itself says that they're both owners of their respective companies. And that's it. There's nothing that designates the son or his company as an agent of.
But aren't we then just ignoring the reality of the situation? I mean, it's kind of surprising, but I guess it makes sense where the dad's like, I really don't, I'm completely hands off. My
Yeah.
son does all this.
Mhm.
And you're saying that we need to ignore the realities of the situation. And because it doesn't say that Cambridge is an agent of, I have it the VP because it does Plaza. I want to say
Right.
Village Pizza because we have
I know.
Village Pizza in Grand
I have
Rapids.
VP everywhere
Yes,
too.
okay, yeah. And that they're not agents of each other, that we have to ignore the practical reality of their circumstance.
Well, and I think too, because you have to look at the testimony as well. I mean, Michael Hamame said, this was something that Village Plaza did on its own. I did not want to enter into this. I did not tell them to enter into
Okay,
this.
but it's so
He did this
what?
himself.
The relationship is
Mhm.
between Village and Cincinnati. There's also a relationship between Village and Cambridge.
Correct.
Again, if the release applies to Cambridge, you're done, right?
Yes, I mean,
Okay.
except I think the liability coverage issue would still remain in effect. Because there's still that
If
exception
not for the
for it.
claims you're making, I don't think, but maybe the other judges do. but,
And
you
that's
know.
part of what I was arguing before too.
Right.
Because we've got that 2021 settlement, we know what kinds of claims were allowed and were basically excluded from that 2018 release and settlement agreement. We know that Cambridge's claims, Michael Hamame's claims do in fact fall within that exclusion or that exception there in that 2018.
Why do you think that again? Just briefly.
Because the business interruption claims were brought by tenants. So those claims, you know, whether or not they're, you know, liability or not, those were the claims that were allowed to go. And they not only went forward, they actually settled with Cincinnati on
Right,
those
but the
claims.
tenants are not under no set of facts, law, principles, case law, statutory or administrative, are the tenants the agents of Village Plaza.
And I agree, this would be
Okay.
a separate issue, even assuming that he was an agent, if he still falls within the exception for liability claims, if Cambridge and Michael Hamame still fall within that exception for liability coverage, I think they still recover under these
That's like saying I
circumstances.
get to sue myself.
Well, no, again, because
How not?
Because again, it wasn't the acts of Village Plaza that caused the building to shut down, that caused it to be saturated for all of those months without any sort of remediation going on. And I would note too, there are in fact tests that are going on. Ms. Snyder said, oh, we can't even do tests, but then actually did tests and all of those tests were negative for asbestos. So for them to basically put out this false narrative that we can't even get in there, we can't do anything until you remove every single tenant, that was not true. That was not accurate.
Was the individuals or business entities that went in to do the remediation immediately after the insurable event took
Yes.
place. Were they selected by Cambridge?
No, it's my understanding that that is somebody that Village Plaza had contacted and said, you know, much like, you know, I've had my basement flood. You know, they cut out the first.
So the dad actually contacted?
No, yeah, I believe that's the case, or maybe even Mr. Michael Hamame as the property manager for Village Plaza. They got somebody there to basically cut out the, you know, bottom
And
couple feet. of
That's
the-
how the asbestos got let loose.
that's what, when Ms. Snyder then came in, she did a walkthrough on January 5th. That was, I think, 4 days after the event had happened. And she saw this and she said, oh my gosh, this might be asbestos. They tested for it and there was in fact at that time positive asbestos.
Okay.
So
But that was not done by contractors or remediation folks that Cincinnati had hired.
not that I am aware
Oh.
of, that I believe that that is correct, yes. So once, and this is our position, is that once she got that positive asbestos number, she saw this as her way of saying, okay, we can't do anything now. We have to stop. We have to get everybody out of here. We got to clear the whole building before we can do anything. And that was the problem. That's what caused all of the damage. We had, you know, feet and feet of water in the basement for months on end. All of the water, the saturation, all of that was just left. And, you know, even 6 months out before the release and settlement agreement was even signed, Ms. Snyder was still sending emails saying, you know what, you've still got tenants in there. You got to get them out before we can actually do anything in this case. So that's as late as 6 months after the initial event that caused the problems with the building. And at that point, there was, I mean, the building was essentially gone at that point. I mean, there was nothing, it would have cost probably, I think the testimony was about $43 million to put it back to post-incident.
The pre-incident
Yeah,
condition.
pre-incident, yes, I'm sorry, yes, pre-incident condition. So, you know, by doing it this way, by requiring them to terminate all of those leases, by requiring everybody to leave and dictating how this was going to go, they saved Cincinnati a whole lot of money by only having to pay out 10 million.
Didn't have to pay any mesothelioma claims either, right?
Not that I know of. I'm not aware of any that arose out of this, but I don't know if there's anything outside of the record. So, but yes, but again, we have expert testimony that says you don't just leave it. You know, under no circumstances is just leaving it the appropriate option. You could, again, shut down the HVAC. You could work on it on weekends because again, the people that are going to work on it, they know exactly what they're
They've got
dealing
the
with.
moon suits on.
Yeah, they're
all
gonna,
the
they're
gas-
gonna go in there and they're gonna remediate the heck out of that building. They know what they're up against. And again, they can shut down the HVAC, which is going to then prevent any sort of fibers from going throughout the entire building, which is the point. That's what they want to avoid. That's what they want to avoid. But what they really needed to avoid was exactly what they did here, which is just allow the building to just completely go away.
Anything else?
I don't think I have anything else to add unless the court has any additional questions. I mean, we have, oh, I did just very quickly wanted just to touch on the legitimate business reason, you know, and I think that's kind of what we're talking about here. I think a lot of my arguments that I made in my brief, I felt a little bit repetitive. I think it's similar arguments to everything that they say. It cannot be a legitimate, or at least all a legitimate business reason to stop work on a building and it's going to cause basically the destruction of that building when that's not what has to happen, that there are alternatives to that.
All right,
Okay.
Judge, anything? All right, thank you, Ms. Whitman.
Okay. Oh, and the other answer to your question, there are about 53 tenants that were
Oh,
removed.
thank you.
Yes,
okay.
absolutely. Okay, thank you.
Appreciate it. Any brief rebuttal?
Definitely brief. I just wanted to reiterate that carve out in the release just means that Village Plaza could seek insurance coverage for liability claims made against it. And then there's the 2021 settlement agreement, also irrelevant because that settled Cincinnati's declaratory judgment action against plaintiffs and Village Plaza. And the deck action involved insurance coverage for tenant lawsuits that were filed against Village Plaza and the parties here, and the assignment for benefit of creditors proceeding. And that settlement obviously came after the 2018 release that we're talking about, and it came after this lawsuit was filed, and that's why that agreement expressly states that Cincinnati reserves its defenses in this lawsuit. So we can still rely on the release.
All right. Fine. All right.
Thank you.
Thank you. Both matters submitted. Thank you for the oral arguments by both counsel, and thank you for the very well presented briefs. The time is 12 o'clock noon. We're going to take a recess until this 10 minutes
Yeah,
after.
perfect.
Is that okay, Judge? All right, we'll be in recess until 12:10. Thank you. All right, please be seated. Good afternoon. Continuing with our 10 o'clock docket. The time is now 12:14. The next case for us is case number 4. It's the matter of Norton versus Bishler Revocable Family Trust. 2 cases. 369-409, 369-453. All right, ready to go. And I was telling my colleagues yesterday after work, I went down, as is my practice when I'm in town. Having grown up in Detroit, I loved going along to Belle Isle. And there, between the Renaissance Center and the downstream tip of Belle Isle are 2 very big lake freighters at Anchorage. And I don't know whether it's because of the wind or what was going on, but then I realized, oh, we have the Harson's Island case tomorrow. So maybe they're here to, maybe they're monitoring this case. But at any rate, we've read the pleadings, we've looked through the many exhibits, and we look forward to the oral argument. So whoever's the appellant, you get to go first.
And by the way, did you guys like project the maps and things for the court? Because otherwise we were with like magnifying glasses.
Me too.
Oh, okay.
Yeah.
I'm glad.
Can I ask a quick question, Your Honor?
Yes.
Splitting our time on the side of the table. I wasn't certain how.
You are, yep.
Treating.
Yes, same. Anybody who's here, no case gets more than 30 minutes aside. So that means for the appellants, and for the Norton litigants, they get 30 minutes. For the Bisher litigants, they get 30 minutes. How you split it is entirely up to you. When 30 minutes is done, you're done. So does that answer your question, counsel? Or not?
There's actually the 12 litigants too. Then this is Charles counsel. I took issues counsel. So we were this.
Right, but you're on the same side of the V. Is that correct?
Yes.
The people on one side of the V get 30 minutes. The people on the other side of the V get 30 minutes. So
And I understand we'll be splitting our time.
yes,
Understood. Thank you. That does.
that's up to you.
I'm sorry to ask the question. Would you prefer to have the appellants both go before I go, or do we?
That's what I'm assuming is going to happen,
I didn't know.
or they're waived. And then it's only 15 minutes. So let me know when you're ready.
All right, thank you, Your Honor, and good afternoon. I represent the Tralfa defendants in this consolidated appeal. The Tralfa defendants.
Counsel, who are you, please?
Darius Dinkowski, I
Thank you.
apologize.
Yep. Go ahead.
The Tralfa defendants have received the brunt of the trial court's orders regarding the alleged trespass that occurred. The Tralfas have been identified as intentional trespassers, and that's
Are you
simply wasn't
reserving
the case.
anything for rebuttal?
3 minutes, Your Honor.
Okay, thanks.
The evidence did not support that. What the evidence did support was that Mr. Tralfa, when he noticed the water backing up on the island, went to the Bisher's predecessor in interest, Miss Osgood, who was a widow, and indicated that he recalled her husband cleaning the culvert and realized that he had passed and asked if he could do that. She granted him permission. When she sold to Bisher, Tralfa again went to Bisher, asked for the same permission. When the clearing of the culvert wasn't taking care of the water issue, Tralfa went to Bisher, asked if he could clean the swale, as we call it.
it saddled both the Bisher and Norton property. Trelva then went to McGeorge's and asked for permission to do work on the Norton property. And that relates back to approximately a year before. The Norton property is vacant. The Trelvas wanted to park some cars on the Norton property for a barbecue they were having in the summer. They knew that the McGeorges had known the Nortons. They approached, asked for contact information for the Nortons. The McGeorges indicated that they didn't feel comfortable giving phone numbers, but that they would act as an intermediary and relay the information because they were deemed as the caretakers, which is the word she
Right.
used.
Had a trial. Trial court totally rejected that. Fair?
Completely rejected
Okay,
that
so
argument.
what's standard of review for the trial court's factual findings? For us, what do you have to show?
Abuse of discretion.
Okay, how is on the record before us, the conclusion that those representations were not made by those defendants or third-party defendants? How is that an abuse of discretion?
They were inconsistent with all the evidence that was propounded.
Fact finder was there, weighed and measured, made a determination.
And they were ratified by the Nortons themselves. The evidence that we've in the appendix, we asked for the permission. There was no doubt about that. That was uncontroverted.
But they never stopped by the house. They never sent a letter. I understand, I think the Bishers provided them with the Norton's phone number, and the Trelfas never went and did this. If he had the experience that you claim that he had of 30 years of working on people's property, he had to have known you can't mess with people's property. You can park your cars on it if you're going to have a picnic. That's not the same thing as going in there, putting a bunch of soil on it, leaving it there to dry out, then redoing it. I mean, the pictures are just amazing. So I don't know if you want to talk more about Badalamente's intervening causation, but they had the ability. This was not a big place. And the Nortons, from what I understand from the record, had a place on the other side of the island. So it's not as if they couldn't be found, check them in white pages, give them a call, anything like that. It's the whole reliance on the McGeorges. And the principal had no indication, gave you no indication, your client, no indication that yes, the McGeorges are agents, as you heard us just doing the agency argument, the last case that we were here. So, and for the most part, the trial court found Mr. Trelfa's testimony lacked credibility.
Understood. And just very briefly, Joseph Norton is a very common name. To open up the white pages, particularly when we found out his home address isn't on Harson's Island, it's either in Birmingham or Bloomfield Hills, made it virtually impossible. They understood that he had a place at the old club, members only. They asked, they would not give that information.
But I thought the Bishers gave him that phone number.
Bishers did not.
I thought that they got a listing from the club. Someone gave them like the listing that had people's names and phone numbers in it.
And I believe that was well after everything that the Trelfas had done
But
had
again,
occurred.
Didn't write a letter, correct?
They didn't have an address. The lot was vacant.
Well, there's got to be a recorded, I mean.
Write a letter to
there-
White Pages. Go to White Pages and send it to that address. You don't
Wouldn't-
have to find them or go there. You just send a letter to their address.
And again, your client is a professional, I'm assuming licensed participant in this business. And we're taking heavy equipment on other people's lands without any written memorialization that you have the authority to do this. I mean, that just strikes me as.
Right, they were neighbors, Your Honor. They were neighbors. The Trelfas
He's
and the
never met 'em.
McGeorges are cordial. Mr. Trelva is not only trying to reduce the flooding on the Norton property, but on the Bishop property, on the McGeorge property, and on his own property.
Well, that's nice, but you
Yes.
can't go in and affect other people's property and then say, oh, sorry, didn't know that I was there, because he intentionally went in, was cleaning out the swale, put the dirt on the Norton's property. That's uncontested.
Uncontested, and left the dirt and the mini excavator for 6 months. Not something an intentional trespasser does to evade detection.
But you don't have to.
That's not an element of
Yeah,
trespass,
yeah.
that I'm doing it surreptitiously in the dark of the night so nobody catches me.
Right, but then Norton ratified that permission. There's clearly a text message from Mrs. McGeorge to Norton saying, hey, and there's some identifying information. The people who bought Don's house, the White House, have parked heavy machinery and are clearing out your drain. That occurs in October of 2018. Norton testifies. He comes to the property December of 18, sees the mini excavator, sees the heavy machinery, sees the piles of dirt, and doesn't do anything. Then September of 19, a year after the work was done, but 11 months after they were advised that Trelva was on their property, then they came to Trelva, who is already done doing what he did, and said, get your pumps off my property. But the pumps weren't on Norton property at the time. He had let that sit for a year.
But wasn't Mr. Trolfa pumping excess water that wasn't draining from a back lot of his into this culvert system?
It was 49 acres of property, and I think Trelfa owns 1.25, 49 acres of property, expert testimony established, drained into this culvert. And that was all
Did
backing
your
up.
client have either electronically, battery, or gasoline or diesel powered standalone pumps removing water from his lot and pouring it into the culvert?
No, that's
Swale?
not into the swale, into the pipe that Badalamenti had installed, because we talked about that intervening and superseding action. And at some point, and it was unclear, Badalamenti testified both at deposition and at trial that he believed he was working for Norton. The trial court found that he was working for Bisher, but nonetheless, Trelfa was not part of any of that. Apparently, Norton had told Badalamenti, put it back the way it was. And Badalamenti, on his own, put in some elaborate pipe and cistern system, which cut off Trelfa's property to a 12-inch pipe opening.
But how do you then do the whole, the Norton said, well, it's okay because we didn't take action right away in December of 2018 when we saw it, that somehow they agreed to all this. If you have the Nortons clearly saying to Badalamenti, put it back. We don't want any of this.
Right, while we were doing it, they were aware of it.
But does that mean then it's not trespass?
Not to the Trelfas, who believed they had permission.
But they didn't have permission. They didn't write the letter to say, we want to go and put dirt on your property. We want to change the way that this swale works because all the people in the back are struggling and we want to clean the swale out. We want to let everybody's property kind of drain and over here. Oh, and by the way, the next door neighbors are building up their property, which is probably going to contribute to that. I mean, the leap you're asking us to make to say that the trial court got it so completely wrong just isn't supported by the record. It's not that somehow the Nortons had to come immediately in December of 2018 and leave a little sign on there saying, get your stuff off my property. And that somehow would have changed the outcome here.
But it goes to the Trelfas' belief that they had permission to be there.
Okay, but that's the point of the problem. They didn't have permission to be there. And if he was this 30-year knowledgeable guy who'd done this, when had he ever just gone to the neighbor where he wanted to work and say, hey, I know you don't live here, but I want to go do some stuff with my heavy loader to this property. And the McGeorge said, well, we'll try to get a hold of them, but never said, yes, you may go ahead and do that. Or why don't you just write a letter, literally write a letter and say, next week, we want to go ahead and clean out that swale.
Yeah, 1 minute left. 1 minute remaining.
Understood. And so
I'm just warning you. So when I say okay, you're done. So
Right, so let's
now
assume.
you have 50 seconds.
For the sake of argument that that's accurate, when Badalamenti came in, he destroyed everything that Trelfa had done on that property. It was not the same. It was not clearing out a swale. It was putting in a pipe and a cistern. All the damages that were testified to at trial, all the experts, all those damages were based on the then condition of the property, which was the Badalamenti pipe and cistern system. There were no damages testified to as a result of what Trelfa had done, yet the trial court said that Trelfa was responsible for putting the property back together the way it was before Badalamenti got through with it.
Okay, thank you. You have 3 minutes for rebuttal. Appreciate it.
Good afternoon, Your Honors.
Afternoon.
Nancy, good afternoon. Nancy Dembinski on behalf of the Bisher appellants. Not repeating the brief, and obviously the court has been hot with some questions. I'd like to start off our argument though, focusing on the pie-shaped parcel. That was the parcel where there were 4 surveys that all took the survey perpendicular from the thread of the St. Clair River and determined that that pie-shaped parcel is on the Bisher's, former Osgood's side of the property. In that regard, there was also no testimony that the Nortons did anything to maintain that piece of property. So number one, we have 4 surveys saying that property belongs to the Bishers. We also have no testimony saying that the Nortons did anything to anything on that portion
They
of the
agreed not to
property.
put up the retaining wall. They talked to the people who were there before, there's the Osgoods, right? And agreed not to put the retaining wall all the way across because it would affect how that worked.
Well, if you believe the hearsay that Mr. Norton was allowed to testify to as to Milton Osgood Senior.
But I thought Milton Osgood's daughter also testified, correct? That
Milton-
her dad didn't do anything, that he had challenged other people on their property before and didn't challenge the Norton situation with respect to that pie-shaped property.
I would say that's incorrect because there's 0 testimony that Mr. Osgood Senior, the deceased, ever had any intent to extend his seawall. It was almost a straw man argument, I would argue, Your Honor, from the record, that the argument was, well, Mr. Osgood Senior never extended his seawall into here because he somehow acknowledged or acquiesced that he held a lesser title to that pie-shaped parcel, although his family and only his family was cleaning it out. There was no evidence that the Osgoods ever decided they wanted to extend their seawall.
Didn't someone say he won or I lost and so that's why I'm not extending it? Or am I remembering the record?
You're
incorrectly?
remembering a piece of it, Your Honor, which I would point out is Peggy Osgood, who is the widow of Denny Osgood, Milton Osgood Senior's son, who is also deceased.
Okay.
Okay. So Mr. and Mrs. Milton Osgood Senior were at the home.
Mhm.
And then Peggy and Denny Osgood being the son, owned the home, and they again cleaned out the pie-shaped parcel. She testified that there was an objection to the Nortons redoing their boat launch or their dock, but that they didn't pursue litigation over it. She said he won that because the township allowed him to do that piece of the dock. And they didn't sue the Nortons at that time. Her testimony was Mr. Osgood Senior already was involved with another piece of litigation. And it was her understanding he was choosing not to try to litigate on 2 fronts. So there was nothing with respect to the seawall. It was only with respect to a permit for the boat dock or the boat launch for Mr. Norton at some point. Forget when it was, 2001,
But there's a
2003.
principle in Michigan evidence and common law evidence of statements about boundaries of an ancient nature are not hearsay,
That,
correct?
if you're talking about 80320, if that is the portion that you're referring to, that is what the trial judge referred to, Your
Okay.
Honor,
Well, go
about
on.
boundaries. Sure.
Go ahead.
And part of what we've argued in that, if it's 80320 that's being referenced, which is what the trial court referred to in the record, it is how the community treats it also, not just what did one deceased former owner allegedly say to his neighbor. And the way that it was treated, Your Honor, was that the Osgoods and only the Osgoods were ever on that property to maintain and clear it out. And again, we have 4 surveys showing that the pie-shaped parcel
Well,
belongs to the
what
Bishers.
community is more important than the community of 2 families that are contiguous property owners, and one member says, oh, the other guy owns it? In that community
Oh.
of fee holders,
Isn't it interesting, though, that he's said it to one person who's the only person of 2 alive? No one else in the
Most
family
interesting.
ever said that.
right? The most interesting thing to me is that the trial court found it credible and admissible.
We would argue that was error, which
Yeah.
is why we have that it is not hearsay or I'm sorry, it is hearsay and not an exception to hearsay because it doesn't fit under that rule. And number 2, Mr. Osgood Senior never talked about extending his seawall or anything else in that regard. We also argued that it was inadmissible to allow plaintiff's survey expert, Mr. Sicko, to testify because he did not offer any opinions during discovery. His opinions were offered for the first time at trial, and that also pertained to the surveys on the perpendicular aspect of the surveys that were provided.
But I thought that some of the other surveys, because the one survey followed Althea Avenue, which made sense, because it kind of had that curve to it. But the other surveys I thought went from the road, but the road it like changed. It didn't have it wasn't straight.
Well, it had
So then they thought about
inconsistent
doing-
widths, so
Yes,
going to the
exactly.
center, there's a lot of,
But I didn't think all 4 of them came from the thread. I
They
thought
do.
Came from the road.
They come from the road to the thread, which is why that pie-shaped parcel shows up in each of them as being on the Bisher side.
So,
And
but that's the problem, because the road isn't consistent. It meanders, it changes. And that's why I think the court decided to go with the Althea Avenue, because that stayed the same. And that was the earliest one, the 2000 survey, right?
And that was the one that was repudiated by the surveyor, which plaintiff's expert was never notified of before he testified. So the first survey, the Hunter survey, there's evidence in the record that in 2001, that survey was revised and repudiated. And Ms. Hunter, the surveyor who did that first survey, literally pulled up her iron. She did not acknowledge that Althea arc as being the proper
But
survey.
you're saying no surveyors came in to say that Althea Avenue was the proper way to go.
No, not perpendicular with the thread of the river. Only Mr. Sicko, the plaintiff's expert, who only relied on that first survey, which was the one that was, I keep calling it repudiated, but revised or revoked.
But again, the thread of the river surveys all rely on the fact that they have to go from the road to the thread of the river.
Correct.
And it's the meandering road information that was brought in by Mr. Sicko to inform the court as to what was happening with that.
I don't believe that was the meandering road, Your Honor. It was the arc road, however, if that's
No,
what you're
because
referring
The
to.
main road, did they go from, was it Circuit Road or? Okay,
Circuit is
was
the
a
one on the
straight road.
shoreline.
Yeah,
Yes,
correct.
They got
Alth-
abandoned.
Althea had the arc.
Exactly. but-
Correct.
But to go from the I'll call it the meandering road, the non-Althea one, the meandering road, it's, it makes no sense, because if the road continues to change, going from the changing road to the thread isn't going to get you what you wanted. Plus Sicko did a full survey himself.
He did do a full survey, but he had exactly 0 opinions on where the boundary lines were when he testified, and he relied on a repudiated survey. And also he acknowledged that the perpendicular from the thread of the St. Clair River was the correct way to establish it. He said,
Don't have-
however, the thread of the river could not be established. And there was testimony that it could be. Multiple different surveyors found the thread of the river,
Okay.
including the experts that testified for the Bishers. As it pertains to the swale or the Mr. Badalamante argument, the court found that Badalamante was an agent of the Bishers when he did his work. However, Badalamante testified that the concept was his own, He didn't charge or contract with the Bishers to do that, and that his testimony was he was following directive of the Nortons to his concept of filling in the swale because Mr. Norton asked him to fill it in. That was the testimony that Mr. Badalamante provided.
Yeah, but also Badalamante was doing the construction of the Bishers property, which if you look at some of the pictures that we were able to pull out of the folders, that it raised the Bishers property about 3 or 4 feet above where it was before. And then you had the swale and then the flooding went way out off to the side. So how you could say that Mr. Badalamante wasn't the agent of the Bishers when he was constructing their house, trying to put the pipe in, the culvert, everything else that was going on there.
Here's why I disagree with Your Honor, respectfully.
No problem.
Badalamante was a builder of the home. Eagle gave permits for the former Osgood property. It was raised and the Bishers built their home. The swale was anticipated to be there always in the drawings. Bishers had nothing to do with asking that swale to be redesigned. After.
But counsel, Badalamante, or however, if I mispronounce, I apologize. They are only there as the agents of Bishers.
I disagree, Your Honor. Mr. Badalamante testified that he was there not to build yes, he was there to build the Bisher house as their agent to build their home.
Okay.
He was there working in that swale area because he talked to Joe Norton and Joe Norton said, fill it in. That is undisputed. That was his testimony.
He wanted it to go back the way it was, right?
And
That's what
so-
Mr. Norton
so
says.
With the instruction to fill it in, he then installs a 30-foot culvert
Yes.
with the flip something on both ends.
That's what he says. It's exactly what he says, Your Honor. And there's exactly no evidence that he received instruction from the Bishers to do that.
Is there any evidence he received instructions from Mr. Norton to do that?
No, he was on his own as far as Norton said, fill it in, and Badalamante came up with that concept. He told Mr. Norton, this is his testimony, I need to put a pipe in. And Mr. Norton says, don't put that on my property. So he asked the Bishers, I'm gonna lay the pipe on your property. And they're like, okay, lay the pipe on our side of the property. That is in no way agency as the builder for the Bishers to do the work that he did on his own when he's trying to satisfy Joe Norton. The Bishers didn't ask him to do it, didn't pay him to do it, didn't conceptualize him to do it. None of that.
So you're saying even though the property was raised up, that wouldn't have affected the swale? There wouldn't have been more water coming
Correct.
into the
Do you
swale?
want to save any time for rebuttal?
I do, I
much?
will save 2 minutes. Yes, Your Honor, and that is
1 minute.
replete within the
1
record.
minute remaining then.
Yep, that is replete within the record, and the Eagle permits and the construction permits were that the swale was not supposed to be changed when the Bisher home was developed. That's correct. And Mr. Phelan, I believe, testified to the same thing, who was engineer, testified for the Bishers. And the trial court,
Try his name?
Phelan, Phelan.
Phelan. Okay.
Phelan.
Yeah, and I also point out that the trial court did find that whatever runoff was de minimis from the actual building of the Bisher home. That was the trial court's finding in that regard, which we're not going to dispute on that. Thank you.
All right, thanks.
Good afternoon, Joe Rogowski on behalf of the appellants or appellees, pardon me, Joseph and Camille Norton. Also in the courtroom is Robert Irie and his clients, Sarah and Frank McGeorge. They won't be arguing today, but so I introduced them to the court. Okay. As this court knows, there are a lot of issues flying around between the Trulfas, the Bishers, and my clients. I'm going to talk a couple of things about what was just said and then get to some of my more prepared remarks, which I know the court has read. But with respect to Mr. Trulfa's commentary that we somehow ratified this activity, I will note that this text that he's talking about, which his client didn't know about until discovery of the case, was in October 26th, to October 26th. My clients don't live on the island. They do have another condo on the island, but they live
What year?
2018.
Thank you.
They live in Birmingham. So they're not on the island in the fall and in the winter. They got this text in October. late October 26th, went out in December. The ground was frozen and there was some equipment on the property. Mr. Norton knew Mike Badalamante knew that his neighbors were building a house, assumed that they just left it there while the winter was happening, left. It was in the spring when the property thawed, the water was flooding the entirety of the area. Mr. Trelfa in the spring of 2019 had then extended a 30-foot culvert into the river. None of that was there in 2018, right? So it was when he saw all of this activity is when we started telling them, stop it. They didn't stop. There's lots of issues here and I understand, but I will say that it's remarkable to me to this day that after 12 depositions, I think, years of discovery, document exchanges, 4-day bench trial, no motion for summary disposition was ever filed. They understood there were questions of fact. No motions to eliminate were filed. Those issues were resolved. They were tried over 4 days in January. And they just don't like the way the resolution unfolded. And so I would submit that with respect to the trespass claim raised by or found by the court with respect to Mr. Trelfa, the only defense to it was the McGeorges was one of them. We've talked a little bit about that today. I would note that Mr. Trelfa admitted that nothing the Nortons did suggested that she was their agent. Nothing. He said it, not me, not Joe Norton. Mr. Trelfa said it. There were numerous texts between Mr. Trelfa and Mrs. McGeorge. Oddly, not one time is there a reference in those text messages about, hey, thanks for the authority, or, you know, I'm going to be on the property. Appreciate you letting the Nortons know. Nothing. Silence. The Nortons sent 2 letters to Mr. Trelfa. Stop it. Did Mr. Trelfa respond and say, I'm really sorry, Mr. Norton. Mrs. McGeorge said we could do this. My bad. No, not a word. He knew that he needed to get, as one of your honors pointed out, he's an experienced excavator. He knows he's got to get property owner permission. He didn't. He actually testified he had the Norton's address, but he wasn't a letter writer and he didn't want to just show up on their door. And somehow that excuses his trespass. It does not. And that is why the trial court, who sat there for 4 days listening to this stuff, said, I reject it. I don't find you credible. And there's nothing that's been pointed out to this court that would warrant reversing that. The Mike Badalamante intervening cause issue was equally not an accurate depiction of what's going on. The Trelfa's contention, the Trelfa's actions, along with the Bishers, they changed the whole course of the drainage in this area. Okay. Much of what Trelfa did remains today. So Mr. Trelfa started by excavating the swale. The Bishers then put a pipe into it. Mr. Trelfa changed took dirt from the Nortons, raised his elevation, put the culvert out into the river. Those things still exist today. He also changed the grade on the Norton's property, which still exists today. Now the Bishers, they put in the catch basin, they put in the pipe. The catch basin connects to the culvert that Mr. Trelfa put in. So this is all interconnected. And that is why the trial court properly and reasonably said, both of you fix it. 50-50. If they want to make a determination between the two of them on who should be responsible for what, that's up to them. But the trial court wasn't going to do that and didn't need to.
Can I ask a question?
Yes.
Okay, did Phelan, who is Bisher's expert, agree that whatever Trelfa did to the swale had no effect on the current Norton property, and Badalamente's improvements replaced what Trelfa may have done to the swale?
I'm sorry, I don't follow. Did Phelan say?
Did Phelan say that whatever Trelfa did to the swale had no effect on the current Norton property?
I don't recall that.
Did Phelan say that Badalamente's improvements replaced what Trelfa may have done to the swale? So and what
Well,
Trolfas are arguing.
it certainly did, because Mr. Trolfa excavated a huge trench partially on my client's property where the swale used to be. Mr. Badalamenti put in a pipe into that trench and then they buried it. The Bishers did. Okay. However, that pipe connects to a catch basin, which the Bishers also put in, which then connects to a culvert extension into the river, which Mr. Trolfa did, not the Bishers. So they are still connected and as one.
And is
That's
the-
what I'm saying.
The catch basin or the culvert that is in the pie-shaped area?
The culvert extension.
It's on, partially on Norton's, depending on.
Well, we
who
contend it's on
owns-
our property.
Depending on who owns it.
Right.
Okay.
And then Mr. Trolfa also put fill from our client's property on top of that culvert extension. I know, Your Honor, it's a lot. And it was a lot to prepare this case for trial and it was a lot to brief it to this court, as you can tell. But the facts are really not disputable, that, or at least certainly not of a manner that would warrant this court stepping in and saying, I don't think the trial court knew what they were doing. So
With respect, can you address the surveys? Because I thought that Psycho did his own survey and found that we went with the ARC.
He did.
Althea Avenue ARC versus the other ones that had to rely on the meandering road, which anytime you get a meandering road out to
I think it was
the,
a meandering size of the road. I
Yes,
think it was a
yes.
straight road that.
not really,
travels-
it wasn't straight. It
Well-
followed the course of the river
yeah, and so that then threw off the
and it
thread of the
widened, it
river.
narrowed. It.
Yeah,
Correct. Yes, I can, Mr. Sicko, as he pronounces
and
it.
that's, I wanted to ask.
I
because
know.
It's SYCKO. I would have asked him how to pronounce it, so I apologize
And
for that.
potato, maybe, but,
Okay.
yes, Mr. Sicko did perform a survey in 2020 that shows the continuation of the arc. That's correct. The Bishers, who were contending that property was theirs, did not present a surveyor who performed a survey supporting their position, which was this perpendicular line. They called nobody who actually did a survey. Instead, they relied on some other surveys, which obviously exist, but nobody could testify as to how they calculated that perpendicular line, taking in conjunction the meandering and the course. Nobody could testify to it because the people who did them were dead. Okay? And they all worked for the same company of the expert that the Bishers called Mr. Pratt, BMJ, yet they didn't have Mr. Pratt do a current survey that he could testify to. So the trial court is left with, all right, I've got Norton, who says I had, and Your Honor, I understand, why did the judge find him credible? But Norton said, regardless of having a conversation with Mr. Osgood, he said, I didn't do that. I didn't extend my wall across because even though it's my property, because I had a conversation with Osgood. Now, that's his own opinion. You don't have to believe he even had that conversation, but that's what he said. And so we've got the court hearing that. They got the court seeing the two seawalls that had been like that for decades, right? The court's also familiar with how this drainage works. We've got a survey from my client only, a witness who could testify to that survey only. And the court made a call. That's what a trial is about. And there's no reason why, nothing that they can point to, nothing that has been presented to the court that would say this court should step in and say, yeah, I think the trial court was wrong. Nothing. It's just they don't like the decision. And I get it, but there's got to be more. And there isn't.
With respect to the argument that the Badalamentes came in and essentially kind of messed things up more, for lack of a better term, right? And then relieve Trelfas from responsibility.
Yes.
How do you address that?
I addressed that, what I was saying earlier, which is they're all interconnected still. The things Mr. Trelfa did still exist.
Okay.
The extension, some of the,
So does Trelfa then have a cause of action against Badalamente if we follow their argument to the logical conclusion?
I don't know. It's up to them.
I just wondered, okay.
Yeah. And so really, there's a lot of other issues. We've got the conversion. See, what happened here was a lot of times Mr. Truffa would say some things and then the evidence would start coming back against him, like with respect to the conversion claim. He testified during his deposition that he took dirt from the Nortons. And mind you, he didn't even say that McGeorge even gave him permission to do that. Like his story about them didn't even apply there. But he said, I took dirt from Norton's, I took dirt from Bisher's, I put it in a pile. And then I took some of that dirt, it was all commingled. I put it on my property because my property was wet. And I took some of that dirt and I put it over on top of the culvert extension that I put onto Norton's property because that's what it needed. And so then they realize like that's putting it to his own use. And they realize it's going to trigger statutory conversion. And he tries to backtrack from that and he fails. And the court noted that in real time and found in the opinion that he did not have credibility because he was not believable. Badalamenti with respect to the Bishers, I'm jumping all over between my two parties and I apologize if I'm getting too quick. Mr. Badalamenti, this idea that he's some rogue agent is just, I can't believe it's still being argued. I can't believe it, but it is. Mr. Badalamenti testified, not me, my conjecture, testified that everything he did had to be approved by the Bishers. Everything. He testified that the Bishers
Does he
approved.
say anywhere below, I did all this stuff about the pipe on my own?
Does he?
Yes.
I don't see that anywhere. Badalamenti? No. He says I approved, he testifies that he approved, that the Bishers approved his plan.
But he didn't charge them.
I don't know
But
if
that-
he
I
did
thought
or
that
didn't.
was
That's
the
what he
testimony.
said.
He said
Yes.
he didn't charge
Right.
them.
The Bishers confirmed this, by the way. They said that they approved the plan. The Bishers
What?
admitted
is
that
is
they
there
could have
ev-
stopped him.
Is there evidence of record of what? I mean, are we talking about a $20,000 parking structure that this person was building for these parties? Or is this a $2 million house? Is there evidence of record what the Bishlers were paying Baldamonte?
No, you're
All
right.
right.
No. It's important, I think, for this agency principle as well, and on top of the things I just talked about, which is everything he did had to be approved, the Bishers approved. The Bishers acknowledged, and so did Mr. Badalamenti, they could have told him to stop at any time. They didn't. They intend to leave it there unless ordered to change it from the court.
Is it still there?
Yeah.
There
Because
is an order. Has there been a stay of that
Yes.
order pen? Okay.
Yeah.
All right.
So this is Wiggins times 10, in my opinion, and it certainly falls under Kratz. And again, this isn't like the most important thing, but never did the Bishers, in response to our letters saying, stop it, come back and respond, sorry, neighbor, that's our contractor who went crazy. Okay?
So the
Yeah.
Norton sent letters both to the Trofas and to the Bishers.
Yes, and they all admitted getting them. And none of them would respond to them. And I even got a call from their lawyer saying, hey, or no, I got a call from Meister Badalamenti saying, what about putting the swale back to its original condition? I sent an email to their lawyer saying, before we sued, that sounds great. Let's do that. Let's avoid this. Crickets. That was the end of it. Next thing we know, they're digging up more, putting in the pipe, etc. So factually speaking, I don't think there's anything for this court to do other than to affirm. Everybody prepared very well for this case, and I think the injunctive relief is wholly appropriate and not an abuse of discretion. And the award of attorney fees as well is supported by Michigan law. I don't know that I have, and I can talk more about it if the court has questions, but I know I can tell you've spent a lot of time on this, as have we. So if there are other questions, I'd be happy to answer them.
Was there any testimony of record with respect to the impact of the injunction? Or is this something that the court fashioned as a way to resolve the issue? But,
Like the impact on the, yes,
Yes.
no, yeah, there was there was record. I thought I addressed that in my brief, that that it can be done. That it will not affect the Bisher's home. And our expert talked about how you would do it. And then Mr. Trulfa testified that it'd take a few days.
Yeah, that's right. And a couple of
Yeah.
big pieces of equipment and.
Right, well, because you got
And a guy
to,
to shovel.
exactly, you have to remember that the Bishers initially intended to have the swale. So putting it back is going to serve the purpose it was intended to do. That's how they intended to build it. But then things started going sideways. So it certainly, there will be no negative impact on either party.
Thank you.
Thank you.
All right. Mr. Dykonowski, you have 3 minutes.
I understand that. I'm going to waive my reply, not due to surrender, just because I'm very impressed with the knowledge the court has of this case already. I don't think I could add anything that you
It's
don't
been
already know.
interesting, that's for sure. It's,
Thank you.
yeah, thank you.
We work hard.
We do, and it's it was not an overstatement when we started this morning. I have never in 7 years on this court coming December had a panel where the three judges have communicated so much about each of the cases. It was just like, man, who's the assignment clerk? And they're trying to put us in an early, they all want me to retire to the state veterans home. I think this is going to do it. So,
No,
all
no,
right,
no.
counsel, you have 2 minutes.
Your Honors, with respect to Mr. Badalamenti's testimony, please, please, please review the Bisher Appellate's Appendix Volume 1, pages bait stamped 451 to 478. Therein, you will find Mr. Badalamenti's testimony about speaking with Mr. Norton with the Fill It In, and him telling Mr. Norton, I need to put in a pipe. His idea. And him
As
asking.
being Mr. Badalamente.
Badalamente, yes, Your Honor.
Okay.
Bisher Appellant's Appendix 451 to, I would read it to you, but I
Okay.
literally have the pages to page 478. Therein contains the prime testimony from Mr. Badalamente that we were referring to. Number 2, I want to point out that council mentioned motions in limine. We did not know that Mr. Norton was anticipating to testify what deceased Mr. Milton Osgood Senior would testify to until the time of trial, and
he
we
deposed?
objected to it.
Was he deposed?
Was
He
Mr.
was.
Norton deposed?
Correct. And there was an objection, however, at the time of trial about what was being articulated to as to Mr. Milton Osgood Senior.
Right, but in the discovery depth, did any counsel who was there trying to find out what the other side might have to say, did anybody give the follow-on question at the end? Is there anything else you're going to testify about?
I don't recall that, Your Honor. And again, I'm guessing is because it's a bench trial too. We do have testimony to a court who's making that evidentiary decision. And
I don't mean to be flippant, but if you didn't, and I'm not saying, if counsel for a party in a discovery deposition doesn't ask a proffered an endorsed witness, is there anything else you're going to testify about? If you don't ask that catch-all question, how do you get to come back later and say, oh my gosh, we were surprised by this?
yeah, and that's just that would be with respect to a motion in limine. That was my point, Your Honor, that then at trial, it's objected to. The surprise was with respect to Mr. Sicko, because he was deposed and said he had no opinions, and the trial court allowed his testimony over objection. Council has indicated, there was no survey, that they didn't have a surveyor, the Bishers testified to, but they did have Travis Pratt provide all of the other 4 surveys that were done and explained how they were done to his knowledge. And they had pictures of the survey irons. So there was testimony in that regard presented by the
I think
Bishers.
you're about out of time, but
Okay. I would also just point out, for Your Honors, that the injunction does impact the Bishers because that pie-shaped parcel belongs to them and 4 surveys say so. Thank
Okay.
you.
Thank you. Thank you all, counsel, that are well argued and well briefed. They'll be submitted.
Like I was talking.
Oh, no, we've all had people talk a lot faster,
Yeah,
believe
no,
me.
you guys, we
I could
can,
hear my voice get loud and fast and I'm like.
we can understand there were different words. That's a good thing.
Thank you.
All right, next case is the matter of Spine Specialist of Michigan, PC versus State Farm Auto Insurance. 2 case numbers 367-653, 371-964. Mr. Hudson appears on behalf of the appellant. I'm not sure. Are you Ms. Rattan?
Yeah.
Ms. Rattan appears on behalf of the appellees, I believe. Nope, it's cross. So, yeah.
We're interchangeable.
Yep. Okay. I'm going to stand for part of this argument, just to stretch my back. So, Mr. Hudson,
And I asked counsel to, or our assistant to turn the temperature down a little bit because I'm like sweating.
oh, yeah. So if we could get this thing.
I apologize.
The only risk of that is might encourage the lawyers to talk more.
Oh,
But,
hopefully not. Hopefully not, but we'll see. But anyway.
all right. Mr. Hudson, you may proceed.
Good afternoon. Good afternoon, Your Honors. Paul Hudson on behalf of State Farm. Your Honor, I'd like to reserve 5 minutes for rebuttal. Your Honors, we're here on two consolidated appeals. One is on the underlying jury verdict, and the issue there is the application of the fee schedule amendments to the No Fault Act. And then the second is the attorney fee award as well. On the first appeal, on the fee schedule issue, that issue is now controlled by this court's published decision in the Dembski case. We had a MOA in the Michigan Supreme Court earlier this year. The end result of that was the Supreme Court denied leave to appeal. And so Dembski controls on this issue. This case is exactly like Dembski, where all of the relevant dates here happened after the June 2019 amendments to the No Fault Act, the policy renewal, the accident, all of the treatments here. And so under Dembski, the fee schedules apply. So on this appeal, that should be a straightforward reversal with instructions to the trial court to remit the verdict.
I'm going to interrupt you for a moment. How was that issue not waived?
The fee schedule issue was preserved in several ways, Your Honor. There was extensive discussion about references to the fee schedules at trial. The trial court considered this issue, decided that there would be references allowed. Then opposing counsel actually invited this result where State Farm would challenge the application of the fee schedules after the jury verdict.
But wasn't that
entered.
rejected? I mean, we have initially there are pretrial motions in limine where counsel for State Farm indicates it would be, I don't know the exact words, but it wouldn't make sense to have the testimony about the fee schedule admitted into evidence. And really later on that changes. There are multiple arguments at the trial. The court ultimately allows testimony about the fee schedule to come in. However, it appears to be left as a question for the jury to determine what is the proper payout that State Farm should be paying spine specialists if they find in spine specialists' favor. And there's a jury instruction that is approved that indicates that the fee schedule does not apply, which is interesting considering they've allowed it to come in. But really the argument is more one of reasonableness. It appears that State Farm is arguing that the fee schedule should be admitted to show the reasonableness of the fees, because some of these charges are pre-July 1st, 2021. Some of them are post-July 1st, 2021. So there's different standards for which we're looking at that. And so, I mean, ultimately, considering all of that, they agree to a jury instruction that says the fee schedule doesn't apply. So how is that not waived?
So after all of those things that Your Honor mentioned, right, extensive discussion of the fee schedules before, during trial, the understanding as invited by opposing counsel was that the jury would enter the award and then State Farm would file a post-judgment motion to remit the award to apply the fee schedules. I'll refer the court to Appendix 123A. I think this is Appendix 17, State Farm's appendix.
So is it Appendix 123A, or that's the page number? of
That's the
Appendix
page number.
17?
It's
Okay.
Appendix 17,
Thank you.
page number 123A. Opposing counsel states if the jury came back with a number they felt was reasonable, isn't this a solution to that a motion where the court decides on the application of the fee schedule. That's exactly what
And who
happened
is the
here.
person who made that comment?
That's Mr. Michael Ratton.
Okay, and then right after that, isn't there a discussion from Ms. Ratton that, no, that was the whole point of the motion in limine to keep that out? And so isn't that ultimately rejected and the court isn't asked to actually give a ruling on whether the judge is going to be doing a post-verdict reduction?
I guess the way I would read that exchange was, we're going to deal with this issue after trial. And so if the issue is simply preservation, was this issue of whether the fee schedule is going to apply to the jury verdict, was that preserved at trial? The answer is yes, repeatedly. And then State Farm filed its motion as contemplated, its post-trial motion there. And then I'll say on top of that, I think this is a pure issue of law. The fee schedule under the Dembski case applies to these charges. And so I think in addition to the issue being preserved, I do think it would be appropriate for this court to conclude that the fee schedule applies to the verdict amount as a matter of law. I'd be happy to answer any other.
I don't understand how you can agree to a special jury verdict form that specifically asks the jury to tell you what it is and agree to special jury instructions that say the fee schedule is to be considered for reasonableness, and how without a very specific memorialization on the record that what we're saying in our jury instructions and our jury verdict form, we really don't mean. What we mean, Judge, is you're going to call all the balls and strikes later. And how is it not that which you suggest, counsel, completely inconsistent with how the case was tried from a defense perspective? It was either he's not entitled to it at all, or none of these are reasonable. I look at this jury instructions and they're approved, and it's now you're saying, oh no, we really didn't mean that. I mean, I'm baffled by it.
I think the way I think about it is, yes, State Farm certainly argued at trial that none of these.
We don't know anything.
None of these were payable. We don't know anything. The amounts.
And if we owe anything, we owe a whole lot less. Yeah.
I think the way to think about it is we're going to take this calculation out of the jury's hands, right? This is a mechanical calculation of just dollars and cents, right? It's not unheard of for a trial judge after a verdict to do whether it's calculations of interest or whatever it is, for the trial judge to handle that post-trial. That's the way it was envisioned.
I had 230 jury trials as a circuit judge, and about a third of them were civil. And I'm the past chair of the Model Civil Jury Instructions Committee for the state of Michigan. I have no professional example to think of that is anywhere close to the position you articulate. And I had your client as a litigant in my courtroom a lot. I don't see how this, one of the questions, how isn't it waived? But.
And I guess going off of that too, Dembski seems to be in a different situation than what you have, because in Dembski, they had a very specific pretrial ruling on the applicability of the statute. And I don't see that you have that. Dembski and the other one, that was right after that, the Maddie versus Town and TAHNN, which is the unpublished case. I thought in both of those cases, there was this pretrial order that says, okay, this is what we're going to do. This is how we're going to apply the fee schedule. And I don't see that order in this case.
No, I agree that sort of the way the fee schedule issue was teed up was different in this case than in others. And certainly as I'm standing here, wish we had a conclusive resolution by the trial judge of applying the law, right? Which is that the fee schedules apply to these
But even if let's assume that you don't have that agreement, okay? I've had lawyers, and we've all seen records where either participated as litigators or as trial judges, where there are lots of things that people don't agree on before we go to the jury, but we memorialize those. We say, here's A, B, C, D, and E. And and when we spell it out in a special jury instruction, we really take time to make sure it's correct.
And was Dembski at jury trial?
No, it was
And neither was Maddie.
correct. Both
So-
of those were decided on
Yeah,
summary judgment,
but-
summary
but-
disposition.
But that to me is also, I think Judge Redford's point is that between the three of us, I'm guessing, I probably had the least amount of jury trials.
But you had a bunch.
I did. And the two of you probably had a ton of them. I've never
Judge
seen.
Bazey, I'm sure, wins the race on jury
Yes,
trials as
yes.
a Wayne Circuit judge.
But I think that Dembski and Maddie are inherently different because it's a jury trial. And then that on top of the fact that you had the jury instructions that were agreed to, where the waiver argument comes in. I think State Farm is not in the same position on these two cases, and these two cases are completely not helpful to you.
Well, I would just say they're in completely different procedural postures, right? And so the preservation issue isn't an issue in those other cases because this issue was resolved on a motion. But if the question is whether State Farm raised the issue of whether the fee schedule should apply to a jury verdict, I think the answer to that is clearly yes, because of all the discussions that are in the record about whether that would happen or not. And if
But
the
it
question
is
is whether
different. But it is different. They argued that evidence of the fee schedule should come in and the jury should hear about it, not that it should be applied to the jury verdict. And that ultimately is what the court allowed. In Maddie, the court allowed, or the court in a pretrial ruling ruled that evidence beyond the fee schedule wouldn't be admitted at the trial, and then ultimately reduced the verdict to be consistent with that. So that is very different than what we have here. The issue of whether the fee schedule should be applied to the verdict, assuming it came over what the fee schedule would allow, was not the argument that was, I think it was mentioned. However, Ms. Maddox ended up Ms. Renton, I'm sorry, ended up rejecting or arguing against that, and the court never made that ruling. There was never a ruling within the trial court that the judge was going to reduce the verdict reduce the verdict to be consistent with the fee schedule, simply that the evidence of the fee schedule would be admitted at trial for the jury to hear.
the trial judge may not have issued a ruling on that issue, but State Farm certainly preserved it in all of this discussion about whether the fee schedule should apply to these treatments post July 1st, 2021. And so if the question here on it, and then ultimately the trial judge in the post-judgment motion did in fact address it. So if we're talking about a preservation or waiver issue on appeal, this issue was raised, presented to the court before trial, when the trial judge had an opportunity to rule on this issue. I think probably the end result of that is the trial judge deferred that ruling until after trial. State Farm duly filed its motion for a new trial or remitted, and the trial judge ruled on that. It is perfectly within this court's appellate jurisdiction to rule on this preserved issue of whether the fee schedule applied.
I'm sorry, Counselor. In my review of the entire record, I see the argument preserved of allowing evidence of the fee schedule to go to the jury. But in fact, in response briefings from State Farm, they indicated that it wouldn't make sense to have the judge reduce the verdict in the reply to the plaintiff's motion in limine to keep the fee schedule out. And so it doesn't appear, beyond it being mentioned one time in trial, it really is not this issue of the applicability post-verdict. Unless there's something you can identify specifically, I didn't see it.
Well, in addition to the places that I did identify specifically, in the time to file a motion for remitted is certainly after the jury verdicts. State Farm filed its written motion for remitted or there, and the issue is still presented of whether, as a matter of law, the fee schedules apply to these treatments that occurred post
Right,
July
but
1st,
you've
2021.
agreed that the law of but after, when you file your remittiture, because the verdict is not that what you believe it should have been, you have already agreed that the law of the case, the jury instructions, which we will ask our sisters and brothers who are the judges of fact to apply, your client has said the law of this case is you can look at them to think about reasonableness.
I guess,
And when I look at page 123 alpha of your exhibit, lines 6 through 10, it says, isn't there also a solution? If the jury came back with a number they felt was reasonable, isn't a solution to that a motion where the court decides on the application of the fee schedule? But I don't see anywhere in the materials I'm looking at that the court says, yeah, let's do that. Somebody says this is an idea, but we don't have an agreement of the parties.
the word I disagree with there, Your Honor, is that State Farm agreed to that. And I'll point to the court to.
State Farm clearly agreed to the jury instructions.
But did not agree. The State Farm certainly did not agree that the fee schedules would not apply to treatments rendered post July 1st, 2021.
You agree that your client, State Farm, agreed that the jury should be instructed, these are for you to consider, these fee schedules are admitted for your ability to consider the reasonableness of the charges.
I think.
Or words to that effect.
The way I read the record is it was sort of taken as a given that this issue would be reserved until after trial. And so then the discussion is about the jury instruction. But let me point to one other place in the record where State Farm clearly.
Call my question. If you do, will you please answer it? Because you haven't answered it.
Did State Farm agree to the jury instruction?
As I essentially summarized.
Yes,
Okay.
with
That's all I wanted to know.
But let me point the court to, this is Appendix 18, pages 125A, 126A. This is State Farm's response to the motion in limine to preclude reference and argument to the fee schedule. And State Farm says, quote, Orlando Benjamin's automobile accident occurred on September 23rd, 2019, after the effective date of the no-fault amendments. MCL 500.3157's fee schedule is plainly relevant and applies to dates of service incurred after July 1st, 2021.
Okay.
And it goes on to
hold
report that argument several times.
What day,
in the response.
what is the date that the jury was charged in this case?
I don't know the answer to that, Your Honor.
Of what year? If we assume that the jury is charged on June something 2023, and the part of the record you have just read was submitted to the trial court on February 20th, 2023, in the posture of a motion in limine to preclude reference to and arguments regarding fee schedule, governmental payers, and other insurance. If they agree to jury instructions 4 months after they file a motion, why does it matter what they did on February 20th, 2023 at page 125 alpha, 126 alpha, and 127 alpha?
Because the issue here is preservation of the argument by State Farm that the fee schedule should apply here, right?
But counsel, if you agree to jury instructions and you do not say while that colloquy is going on with the trial court, Your Honor, we agree with these instructions, with the proviso, of course, that we preserve the issue of A, B, C, D, and E, as happened literally scores of times when I was a trial judge. If you don't say those after you have a pause that if we were looking at as a written document would be a semicolon, however, comma, I preserve these issues. If you don't say that, how do you preserve them?
Yeah, I understand, Your Honor. And the jury instruction was not inconsistent with State Farm's argument that the fee schedule should apply. In fact, the jury instruction says you can consider the fee schedules during your deliberations
Right,
about
for
this
the
case.
reasonableness of the charges made.
Right. That's not inconsistent with State Farm. That's not State Farm agreeing that the fee schedules don't apply, right? Those two things can be consistent. And so when State Farm said pre-trial that application of the 3157 fee schedule for dates of service post July 1, 2021 should be a foregone conclusion at the trial court level unless the accident occurred before statutory amendments. That's State Farm maintaining all the way through, certainly not consenting to or waiving that argument once they get to trial.
I do not understand how that is a correct statement of what the civil procedure rules are for the state of Michigan, but maybe there have been changes since I left the trial bench.
No, and I don't mean to argue with the court about that. I guess
Argue away. That's what you're paid for.
we have a pretrial preservation that fee schedule should apply, right?
Right.
And then we don't have a position that State Farm takes at trial that is inconsistent with that preserved issue, which is then raised again post-trial directly in the motion for new trial or remitted.
Okay. I understand your position.
Thank you, Your Honor.
Thank you. And I don't mean to be confrontational, Mr. Hudson. You know, I think the world of you and think you're a very, very fine, and I get to say this because I'm an old goose now, a very fine young lawyer. I used to hate that when the older judges would say it to me, and now it's me saying it. But you do a great job for your clients. I didn't mean to suggest anything to the contrary in my questions. Counsel.
Good afternoon, judges. Rachel Ratton on behalf of Spine Specialists. I'm the appellee in this first case, and then I'm the appellant in a secondary case. I assume the court wants me to move from one into the other.
Only if you want to talk about it.
So I would request to reserve 5 minutes of my time to respond to any comments Mr. Hudson may make in response to my attorney fee motion. I don't expect I will really need them given the position State Farm took below on my request for attorney fees, but I just want to preserve that. Judge Bazzi, you have it exactly correct about how this issue came up in trial. I think reading the entire trial transcript shows this issue got very muddy and got very complicated throughout the course of the trial. But the reality of the situation is that on the final day of trial, State Farm did agree to a jury instruction that says, quote, the statute is not binding on this case. And it wasn't just a, yes, Judge, I agree. And, let's move right into closing arguments where perhaps defense trial counsel, needed a minute more to place an objection on the record. And it's cited in my brief, he approved the jury instruction multiple times. I think there were 3 different instances where he said, the defense accepts it. It's good for the defense. I'm fine with that language. And then that was the jury instruction that was
Can I ask a
read.
question?
Yes, sir.
Judge Matthews was the PJ, the presiding judge, right?
Correct.
What is that judge's practice as far as, here's the instructions I'm gonna give. Not just here's the numbers, but here's soup to nuts. This is what I'm given. Does the jury get a copy of them? Let me just explain. And the reason I ask, back in the day, juries that were in front of me, because of my Marine and Navy experience, they got 100% of the jury preliminary instructions in writing, 14 copies in criminal, however many copies in civil. And same thing, I think, with Judge Feeney. Most of our judges in circuit, Kent did it, and they get the exact same thing. So, I mean, there's no question of what the instructions are going to be. What does the courtroom look like in Judge Matthews' courtroom?
This is my only trial in front of Judge Matthews. But my understanding, based on prior conversations with the court about, what is going to go back to the jury and in what form and at what time, is that all jurors got a printed out copy of the instruction. If the court looks at the last volume of the trial transcript, when conversation was happening about the special jury instruction, this started first thing in the morning when we got there for the final day of trial. Court and counsel had a very long conversation about what that wording would be. It went back and forth. Judge Matthews went into the back, made some tweaks, came back out, presented it again to the court. or to council. We had more conversation. We agreed on a
Obviously,
verdict.
no, I didn't read the entire record now that you're sharing that. So, okay, my colleagues, I'm sure knew. this, so,
But
all right.
this was a very long conversation where there were multiple opportunities.
So it's not like back in the day when, years probably when, before you were in grade school, you'd go in and the judge would say, okay, I'm going to give 1.1, 1.3, 1.7, and you get a list like this, just with standard jury numbers.
Oh,
This
no.
is, you get the whole thing soup to nuts, so everybody knows what we're dealing with.
Yes, sir. Everyone knew what we were dealing with. There was actually a pretrial motion in limine that I had filed requesting special jury instruction. So we'd already had, not about this issue, but myself and defense trial counsel had already had a conversation with the court about special jury instructions and what instructions will we agree to? What will we not? How is that going to go back to the jury?
Thank
So it was well briefed and argued and preserved from the standpoint of what was the jury going to be instructed on, and State Farm had every opportunity to object or to state the position on the record, and they did not. And I know, Judge Redford, that you authored Dembski, and I'm really not here to, express my views on that opinion unless the court would like to hear them. But I do think this case is different from Dembski in the ways it seems like this panel has already identified. And similar to Maddie, but Maddie was prior to Dembski and is unpublished and publication was denied. So I'd like to focus on Dembski. In Dembski, that insurer, State Farm again, although represented by different trial counsel, filed a motion for partial summary disposition asking that the claims in excess of the fee schedule be dismissed. And in Your Honor's opinion, in that case, in a footnote, the court described what was presented to the trial court along with that motion. And it was a copy of the plaintiff's complaint, all of the HCFA Form 1500, the bills, what the computations would be under Medicare. The plaintiff did not object to that. Your Honor, it looks like he wants to ask me.
No, I don't
Oh, okay.
No,
I didn't want to cut you off.
No, you're doing great.
So there was a plethora of documentary evidence in Dembski about the application of the fee schedule, and that's acknowledged in the Dembski opinion. That does not exist in this case. Even in State Farm's post-trial motion for remittitor, its fee schedule calculations were not presented to the court. State or spine specialist disputes those calculations, and the trial court knew that, defense counsel knew that. State Farm presented, I believe, 3 or 4 different calculations of the fee schedule in the course of this litigation. I simply do not believe this issue of the fee schedule was litigated properly by State Farm below. Setting aside how I may feel about Dembski and how that should apply going forward to these fee schedule straddle cases, which I hope are starting to dwindle, that's really not the issue here. Even under Dembski, State Farm did not litigate this issue properly, and then they didn't preserve this issue. I do just want to touch on, in case Mr. Hudson brings it up when he comes up here, the effective date and when this policy renewed. I just want to make it clear for the record, although I think it is clear in my briefing, the policy in this case was originally purchased in 2016.
Mhm.
The declarations page that was in evidence agreed to as a stipulated exhibit by both parties has a renewal date that predated the change in the law of June 11th of 2019. State Farm has maintained that actually this policy renewed in August of 2019, August 23rd of 2019. There is no actual evidence of that in the record. State Farm cites to some discovery depositions.
Well, isn't there testimony by, I believe, State Farm's representative that it was renewed 2 months prior to the date of the accident? And so there might have not been an exact date, but isn't that evidence of when it was renewed?
So she does testify, Ms. Ellis, that it renewed a couple of months before. She does say that. State Farm.
2 months, I
I'm sorry.
believe. I thought she said 2 months.
I thought she said a couple.
Yeah, I thought it was 2, but that's how they went. They went back the 2 months.
Yeah, she
From
said
the
2 months
accident.
and then she used the word a couple. So
Yeah.
she said 2 months before. The accident is what, September 23rd, 2019. 2 months before would be,
Could be
Sure.
August, could be
it could be August, it could
July,
be July,
could be June.
but it's well after June 11th, 2019, 2 months.
And what I would say to that is 2 parts. The portion of State Farm's claim file that they rely on for this effective date, that was never, highlighted or called to the attention of the court or to the trial counsel. And the evidence of renewal that was presented in Dembski, just by way of comparison, was a document of an auto renewal that specifically said those dates, and that was an exhibit to that summary disposition motion. That really doesn't exist in this case, but taking Your Honor's point that she did testify, she testified it renewed a couple of months before. the trial court on the final day of trial, when can't recall exactly what portion of the argument this came up at, but State Farm made a kind of a passing comment about the renewal date. And the trial court said at that time, I don't know if the policy is the same, but the trial court has not heard that it isn't. And that happened after the close of all of the evidence. So I think it was incumbent upon State Farm in their post-trial remitted motion to say, Judge, here is the evidence of this renewal. Perhaps you missed it during the course of trial. I know we didn't call your attention to it. I know we said this very amorphously about a date, but here's the evidence and it is in the record. And that August 2019 date has never been presented the way State Farm intends to present it on appeal. But I really don't think the court even needs to get to that because of the issues with preservation and the issues about how State Farm litigated this case from a fee schedule perspective below. There are no other questions at the fee schedule. Oh, is he going to rebut and then I do my?
Well, let me ask you with respect to that, because I think that I saw the citation in State Farm's brief that, well, every renewal is a new contract. And I think in yours, there was a reference to the fact that, no, it began in 2016. So it was just continuation of the contract.
That is spine specialist position. This policy was purchased in 2019. The policy booklet actually has a copyright date of 2009. And there is no evidence in the record of even a renewal after the date on the declarations page, which was April of 2019.
Okay.
So that's why there's been this, kind of continued argument between myself and State Farm about when was this policy purchased or renewed, and that I think it's important considering whether or not the fee schedule would apply, but the court doesn't even need to decide that because of the issues with agreeing to a jury instruction that said it's not binding on this case. I'm comfortable with whatever you want.
Thank you.
However you want.
What would you like to do?
I can come back
Okay.
after Mr. Hudson is.
Thank you, Your Honors. Just on the policy renewal date, that is in the record. It is August 23rd, 2019. That's in the appendix, page 41A. The policy originated back in 2016, but look, I mean, my no-fault policy originated back in 2006. I'm quite certain that the law of 2006 doesn't apply to the renewal of that policy. And then I don't want to belabor the point on preservation. On page 3 and 4 of our reply brief, we laid out all the places both before and during trial where the fee schedule issue was raised and presented to the trial court. And then in addition to the one passage that I read, there were 2 other instances where spine specialist counsel invited exactly what happened here, which was State Farm renewing this issue after the verdict and applying the fee schedule to the verdict amount. I understand that the court has some concerns about the way that was raised. Perhaps it wasn't perfect, but
No trial is ever perfect.
no,
so.
and sometimes you get an indication of where a trial judge is going on an issue, and you're not going to keep coming back to it over and over and over. Preservation is a pretty low bar. You have to raise the issue, present it to the trial court for a ruling.
That's a good point.
And we have then post verdict motions.
Grouchy trial judges, Mr. Hudson? I've never heard of such a thing.
Well, that's why I'm an appellate lawyer, Your Honor, because I've never met a grouchy appellate judge.
Oh, until today, right?
Thank you, Your Honor.
All right. Thanks, Mr. Hudson. Counsel.
Thank you. I obviously have a lot to say about the trial court's ruling on my motion for attorney fees and costs. But as Judge Kavanaugh has told me more than once when I've appeared before this court, the best argument is one that answers the question of why should I win? And I think that question is answered very easily by this court's decision in Commandant and in Tinnen. And both of those cases address attorney fee no-fault awards. I think when you compare what Judge Matthews did in my case with what happened in those cases, it's very clear the errors in her opinion. And I do think that there are errors all over the place in the judge's opinion. I think it was error that the court declined to award the only remaining costs that were not awarded that remain in dispute regard the expert witness deposition fees. No one objected to those fees. I don't find them to be unreasonable. State Farm certainly did not. And yet the court kind of on its own and without really explaining why she believes these expert physician witnesses should be paid less than what they had asked for and what plaintiff paid, said they should be paid at a rate of $500 an hour. I do not believe that is reasonable. I also, and I pointed this out in my brief, I believe a ruling like that invites a proliferation of motion practice that frankly the trial courts do not need in the realm of no fault, because if the two parties don't believe in a expert witness fee is unreasonable, allowing Judge Matthews' decision to stand, those parties nevertheless should be going to the trial courts prior to discovery depositions and saying, Judge, I don't find this unreasonable. Opposing counsel doesn't find this unreasonable. Obviously, the physician who set the rate doesn't find it unreasonable, but we want Your Honor to pre-approve that if this goes to trial and if we are awarded costs, we will be reimbursed the full freight of what we pay for this expert. And I do not believe that is how these issues should be handled in the trial court. As far as, and that is the only cost issue that remains outstanding, are the deposition fees for the expert
What's
witnesses.
the difference between what was sought and what was approved?
Judge Matthews awarded $750 per doctor, and there are 3 doctors, and I am awful at math. So $750 times 3 is what Judge Matthews awarded, and what the plaintiff had requested was $2,700 for one, $3,000 for the other, and $2,250 for the third. So quite a bit less. I don't have that
Was there any,
math done.
in the case management order, was there any limitation on how long discovery depositions or debene essay depositions could be for experts?
Absolutely not. None
And
whatsoever.
they were all pretty short. I remember I see it was like one was an hour and a half, one was like almost 2 hours, like an hour and 45. And
Yeah, I
then it was
don't-
like another hour plus.
I don't believe any exceeded 2.5. One may have butted up right to 2.5. They weren't particularly long depositions. But I would say, even though 2 of the 3 doctors whose fees I would like to be reimbursed for were on the other side of this case, all of those doctors are very well qualified physicians. They are all names that those who practice in the no fault arena know. So I think they're justified in the fees that they charged. Whether or not I agree with their opinions isn't really what matters. What matters is, do I think the rates they were charging were commensurate with their experience? And I do, and I think they're reasonable, and trial counsel below never disputed that. I'm not sure why Judge Matthews saw to it to make a call that I don't frankly believe she needed to make.
Well, didn't she, when I was reading through her opinion yesterday, didn't she make some statements with respect to why she was doing that? That there was no evidence that was presented with respect to their rates and the reasonableness or something along that line? I'm trying to remember.
I believe what she
It was
said
in-
in her original order was just that she did not. It appears Dr. Nozoma, Dr. Park, and Dr. Garver charged and were paid in excess of an ordinary witness fee, but this court was not provided with a minimal appearance fee and or hourly
Yes.
rate.
Right there.
So I acknowledge we did file a verified bill of costs that had all of the numbers and dates in it. We did not attach, copies of the checks or the fee schedules that we had been given from the IME experts and then Dr. Nozoma, because frankly, they weren't in dispute. Upon receiving this original opinion where it became very clear that the trial court had an issue with what plaintiff had paid and what was not opposed to by State Farm, we did provide those in response, in attachment to our motion for reconsideration. So the court had that before her when she again declined to award those costs on reconsideration. She did award other costs that she had previously denied on reconsideration, but she maintained her position with respect to those IME physicians and then the other position of spine specialist.
So is it true then that while those experts were on the stand, nobody said, well, how much you charge per hour?
Oh, no, that was in their trial testimony. It was asked, depending on whose witness they were, what were you paid? How much does it cost for you to be
Okay,
here
so remind me,
today?
I'm sorry, it's just getting late in the day.
We have 2 more cases.
Yeah, I know. Just remind me, what were the 2 things you said that were missing?
She said their minimal appearance fee and or hourly rate.
And the hourly rate didn't come in at trial?
I believe it did. I don't have, my record is at my desk, but
Because that would be, every
It'd be
expert
very
I've ever had
abnormal.
sits there and says, this is how much I was paid and this is what my hourly fee is and.
correct. I I would be willing to bet on for all three of these positions, those numbers did come out in their trial testimony. I know they did at their discovery depositions because I took those depositions. And that was all in the record and presented to the trial court. So she
Thank
did have those, and then we did provide the fee schedule
On reconsideration.
on reconsideration. Yes, ma'am. So that's really my only issue with respect to costs. My issue with respect to the trial court's decision on attorney fees is similar in that I feel that the trial
What's
court,
standard of review?
it would be abuse of discretion, but of course, the erroneous application of the law is per se an abuse of discretion. And I believe, if I recall my standard of review correctly, the court reviews factual determinations underlying fee awards for clear error, which is left with a firm and definite conviction that a mistake
So
was made.
why is the
Is that-
attorney's fee decision of Judge Matthews clearly erroneous?
Because it does not at all comport with Commandant and it does not comport with Tinnen. In addition, it was never disputed by State Farm that the hours expended and the attorney fee rates requested were reasonable and should be paid. And I think that is very important, especially.
Did they stipulate to it?
They did not stipulate.
Okay, so the duty is on under peer review and the other cases, the duty's on the trial court to, call the balls and strikes on the attorney's fees.
I would agree. I would say
The
that
judge gives this 10-page, single-spaced opinion and order. I've never seen as detailed an opinion for attorney's fees. Never.
I
In
don't,
40 years.
I would say I don't believe there was no ball or strike to call is how I feel about this because State Farm did not oppose the hourly rates or the hours expended.
But
It is
that's
true
not
they
the
did not
standard.
stipulate.
I mean, trial courts have sent back so many times. You didn't make these findings. You didn't apply these steps. Whether or not the parties, and again, like we talked about on the other issue on this appeal, there was no stipulation that certain aspects of the fee schedule were going to be relitigated afterwards. And I think you saw at least there might be some reservation in this panel, but because it wasn't memorialized. Same thing can be said about the attorney's fees, about the hours. She says, all respect to you, counsel, you sent in your an alumni of my alma mater, go UAD. It used to be UAD when I went there. And you did great things. And Billy Booth's Law Center, who was one of my law partners at Plunkin and Cooney, you did great things there. But the trial court made an assessment. I think that the hourly rate that this lawyer charges is too high. I think this is more in line with what is consistent with this case. I mean, I don't know how it's an abuse.
What I would say to that point.
And I'm not knocking you or your
Right,
dad,
absolutely.
or I think it's your dad.
It is my dad,
Yeah,
yep.
yeah, so
I'm always hesitant how I answer that question when people ask me, is my dad and your dad? I say, why?
Yeah,
Before I
see,
answer.
my daughter, who's a lawyer, took a married name, so
Okay.
she doesn't have that problem.
Yeah, I probably should have taken my husband's name, but setting aside how I feel about the fact that this wasn't contested by State Farm, I don't believe, and I understand it was a 10-page opinion. I understand it was then, I believe, 3 pages on reconsideration. My read of those opinions, the only factors of Smith and Purgu that Judge Matthews touched on were the hourly rate and the hours expended. There was no further discussion of those other factors, such as, the time, or I'm sorry, the expenses, the result in relation to what was requested, the length of the relationship with the client, all of those other factors that the case law is very clear the trial court has to discuss, those are wholly absent. So even if this court felt that, setting $350 for me and $375 for my dad, even though he's been a lawyer for 35 years, that is somehow reasonable, I don't then understand how that decision can stand when there was no additional discussion of the factors. And setting even that to the side, even if all things are left as is, and I should be paid at $350 an hour, my father should be paid at $375. Okay. I believe what the trial court then did is essentially like double dipped on the hours in an apportionment that is expressly forbidden by Commandant, because if the court looks at Judge Matthews' opinion, when she excises certain hours, she says, I'm excising these hours because I believe they are in relation to benefits that were not awarded because of the calculation of the interest on the total awarded. She does this mathematical calculation. And the case law is very clear that an attorney should be paid for all of the hours spent in pursuit of the claim. And the case law is also clear that once a claim is found to be by the trial court unreasonably denied such that an attorney fee should be paid, the attorney should be paid for all of the time expended in that litigation unless the time is only attributable to some benefit that was found not to be
Trial
overdue.
judge extrapolates based on the percentage, the 12% interest rates. That is the amount of interest that's awarded, that just using basic reverse engineering, the jury must have concluded that only X was found to have been unreasonably withheld.
So I would just take issue with how Your Honor phrased that. The jury determination is whether or not the benefits were overdue, and then the trial court has to decide whether or not that denial was unreasonable. So those are two distinct issues, and it is not, the jury isn't saying, I find these other benefits awarded that I'm not giving interest on, that denial was reasonable. So those are two different determinations that need to be made by the trial court. And the trial court took the award on interest, which I do think it's very illuminating, the question that was asked by the jury, which is, if we answer yes to interest, do we have to award the full value, or can we specify a given amount? I think that makes it clear they were looking for a way essentially to not punish State Farm to the full extent that they would have been able to under 3148. And the court and counsel answered, no, you do not need to award the full amount. You can specify a given amount, and that's what they did. I don't see how that somehow means that the $435,000 they awarded in overdue benefits, which was every dollar the plaintiff asked for in overdue benefits, somehow were not overdue. And again, if you look at the things that defense trial counsel agreed to in the trial court, defense trial counsel agreed that these benefits were overdue, as did the trial court.
Right, but you don't get attorney's fees if there's a reasonable dispute, right?
Agreed, 100%.
Okay, so the trial court, okay, I understand your position.
And what the trial court said was, I do not believe State Farm's denial was reasonable for the claims that predate the cutoff date. That was the trial court's ruling, which is why we were even entitled to an award at all. And that ruling has not been challenged by State Farm. The trial court then said, I am going to essentially apportion the hours requested by counsel, set aside the dollar value. I'm going to then apportion the hours requested using this calculation of the interest awarded. And I don't believe that is in any way supported by the case law. And
So you're not challenging the time billing that she had there as being not attributable to securing payment for bills before March 15, 2021, that were excessive, unnecessary, involved strategy sessions, or the description of work was insufficiently phrased. That's what she did in the chart.
correct,
We're done. You're way over the 5 minutes, so
okay.
appreciate everything you've said. Do you want,
No.
or do you need an answer?
Yeah, if you, just real quick.
My answer is yes, she pulled certain hours out that she believed were not attributable, and then she further deviated down to pro rata it according to this other calculation. So
And
she did it twice and should not have done either one of those things.
Thank you.
Okay,
Thank you.
go Titans. Do you still have more to say, Mr. Hudson?
No, I don't, Your Honor. I think the heart of this is abuse of discretion standard. We have a 10-page opinion from the trial court, carefully reviewed all of these. It's not outside the realm of principled outcomes to decide that $500 is better than.
Should the judge have been more specific on why we're in, I think it's the 50th percentile instead of the 95th percentile, or what's the burden on the court to do that?
Well, I think the court explained the reasoning, with respect at the time, it was a fourth-year associate trying the case, right? The trial judge actually bumped it up from initially $300 an hour to $350 an hour. I think that the takeaway here, though, is these are well within the trial court's discretion. I'll rest on the.
Articulate all the peer review factors every time.
The trial court certainly laid out the peer review factors in the decision. I think the best way to read it is she incorporated those factors into the analysis as she was doing the calculations and the reverse engineering and all of that.
Yeah, okay.
Yeah, but
We
then
have
did
just a second.
they didn't do the trial court did not do the upward or downward. I mean, that they essentially she did the reasonableness, she did the number of hours, but then didn't do the up or down.
I think it's fair to say that, not expressly, so.
Okay,
Yeah.
yeah, makes
Okay.
sense.
Thank you. Your Honor.
Anything else?
No,
All right, these matters are both submitted. Thank you both counsel for your spirited answers to our spirited questions. So well done.
Thank you.
Next case, we ready to keep going or?
no, yeah, I'm fine.
Sure.
Okay,
Let's get
next
through these.
case is Johnson versus Beaumont Hospital of Trenton, 369-349.
It's like motions. Those marathon motions.
Yes,
Eight
yeah, on
thirty in
Friday.
the morning to 2:30 in the afternoon. It was great.
Oh my gosh, where do these orders come from?
They've been hiding in the back. And thank you all for your patience. I know all of you have been here sitting patiently and waiting patiently. And I told my colleagues, I said, boy, if everybody uses their half hour today, we'll be here for over 7 hours. So. Oops, where'd my notes go?
Good afternoon, Your Honors. Logan Francisco, appearing on behalf of the plaintiff appellant here. I'm going to keep my arguments brief because there's been a lot of case law that have come out since the briefing in this on this particular issue. The law has changed. So I'm going to focus on two of the facilities that we are saying immunity does not apply to based on the new law. When this case was briefed, all we had was the Warren decision. The Warren decision, as Judge Redford authored.
I called Franklin. I thought everybody else said so.
Warren, Frank, it's funny enough, Your Honor, I think the names got flipped somehow.
Oh, did they?
Yeah, and so it was our client and yeah, but so the Warren decision came out, or Franklin decision, whichever it is. It expanded the Pandemic Healthcare Immunity Act, at least the meanings under the statute of what by reason of services provided in support of the state's response to COVID-19, what that actually meant. Following Warren's sort of expansion, there came the Skipper Baines case, which the court found that there was no causal connection to COVID, and because no causal connection, no immunity. And then most recently, we have the Jokinen decision, which sort of pulled back Warren a little bit, saying that, it's not every single case in which, a patient is in a hospital during this time during COVID that their injuries or the defendants are subject to immunity. There's the statutory language still exists. It still has power, and that the injuries have to be by reason of services provided in support of the state's response for COVID-19.
So among these three cases, where do you believe that Mr. Johnson falls? Because he was admitted for COVID, he was treated for COVID, so it wasn't like the second one, the Skipper's Baines one, because that had nothing to do with COVID, although, was that the one where they decided they may have had COVID when they died or whatever that is?
Yes, Your Honor,
So-
yeah.
So where in this, because we kind of have these three cases, where does Mr. Johnson fall in here? Because I don't think he falls outside the coverage case.
Understood, Your Honor. I think this is somewhere outside of the three decisions we have. I think as far as defendant Fairlane and defendant Prime, this was not circumstances in which Mr. Johnson was laying on his back in a sick induced coma or was out of it where he would be turned or repositioned and desaturate because of that. He was actually getting quite better. He was on a vent when he was at Beaumont originally. He got off the vent, his breathing continued to improve. So this was not a situation where he wasn't able to be turned and repositioned. This is not a situation where he wasn't able to receive wound care because of something related to his COVID diagnosis. And what we're saying is that the defendants here, Fairlane and Prime, did not provide proper care. They didn't turn and reposition Mr. Johnson as they should have. And the progression of the wound, which is what we're claiming as damages against those two facilities, occurred irregardless of the COVID-19 treatment, COVID-19 diagnosis, or symptoms related to COVID-19.
But I thought they all began when he went in for the treatment. I thought that's when the right buttock and the abrasion occurred. That was when he was in the hospital. So how can you say that the continuation of that buttock ulcer and the abrasion, that it was unrelated to COVID?
Well, because the pressure wounds, if treated, stop. They will eventually get better. They did not in this case because of the lack of care. So that progression of the wound when he got out of Beaumont and was not on a vent, he was able to be treated. That progression continued. The wounds got worse. They got larger.
But it wasn't as if he was no longer bedridden, correct? He was mostly in bed during the time that he was released from Beaumont. So it's not like if he was like up walking around.
Correct. But our argument is that irregardless of, he was able to be treated with wound prevention, with wound care that would have prevented that the enlargement of the wound eventually becoming infected, and the further damages that occurred after being released from Beaumont, after being on the ventilator.
So you're trying to then draw lines between the Warren case, right? Yes,
Yes.
Warren. You're trying to say, okay, even though it was COVID related, we can say that once he was released from his COVID treatment, that is there like a way you guys refer to this act? Because it's hard to say.
FICA, I think,
But I
right?
think it would be a PH, so it'd be like more of an F.
Yeah.
Yeah,
FICA. That's what I said.
FICA.
Yeah, like FICA.
Yeah.
Or something like
I
that.
thought everybody said FICA.
Yeah, me neither. But anyway.
So Your Honor, our argument is rooted in the strengthening of the statutory language that the Jokinen kind of did. We're saying that this progression of this wound cannot be considered by reason of services provided in support of the state's response to COVID-19, because irregardless of that treatment or that diagnosis, if they had provided that proper care, the wound would not have progressed. He would not have incurred those damages beyond what had occurred at Beaumont.
But you can't necessarily, I mean, I don't think you're an expert that said that had they just given him decent care, everything would have been better, because still the damage, the ulcer, the abrasion occurred at the time he was being treated for COVID. So to me, that means he's covered by it. The things that flow from it, Warren doesn't say it stops once you get this point. Franklin doesn't even really because Franklin is, I think, distinguishable in its facts. Is it Franklin? Am I talking about the right one?
It's Franklin, but we're calling it Warren, I guess.
That's right.
Yeah.
Okay, super. But I don't see any place in these cases where the distinction you're trying to draw is supportable. And if you could cite me to a case that supports what you're saying, or a line in Warren/Franklin or in Jokin or somebody else that supports that piece that you're saying, that once you're released from COVID care, then everything changes and you're not protected anymore.
Yeah, well, Your Honor, I don't think there is a case, and I think that's why we're trying to draw that distinction. I think what we are focused on is the damages here, and to sort of cut off liability at Beaumont where he incurred the wound. That's not, encompassing all of the damages here. And we're arguing that Fairlane and Prime Healthcare or Home Healthcare were in and of themselves negligent in their own ways other than what Beaumont did. So those two defendants, we believe, should be on the hook for damages that still occurred beyond Beaumont that were not related to COVID-19 or not by reason of the services being provided by those two.
But wasn't he continuing to receive COVID-19 services through those facilities?
To a lesser extent, he was.
But he was.
Yes.
Okay. And wasn't that during the same period of time?
Some of it was. Some of the care from Prime Home Healthcare went outside of the statutory timeframe. I believe the statutory timeframe cut off July 14th of 2020.
Wasn't there some type of agreement, at least with the lower court, or understanding that it was within the statutory time period? Although some of it might have gone outside, there was ultimately a consensus that this happened within the statutory time period,
Yes,
correct?
there was an agreement, yes.
Okay. So he's still receiving care from COVID, and it's within the statutory time period then?
Correct. And our contention at this point is it can't be considered by reason of those services irregardless, because the COVID treatment, the diagnosis, any symptoms he was receiving because of COVID had nothing to do with the fact that he couldn't be treated for wounds and he couldn't be turned and repositioned. There was no basis for that. I want to leave with this. If the same wound progression would have occurred absent that COVID-19 care, the treatment, whatever it is related to COVID-19, we feel that it cannot be under the statutory language by reason of those services. So with regard to Fairlane and Prime, we're requesting that the decision be reversed. Thank you.
Great, thanks, counsel. Any other questions?
No.
All right. Ma'am?
Good afternoon, Jackie Klein on behalf of the Beaumont defendants. We're gonna go in chronological order here. With respect to all the case law that's come out, a lot of it has involved the same attorneys. So I think this case is virtually indistinguishable from Warren. There have been at least 2 cases on each issue here. Immunity for pressure ulcers when treated for COVID was addressed in Warren, in Harris, and Monroe, and is exactly the same situation we have here. The rejection of the gross negligence and the constitutional arguments were rejected in both Warren and Harris, and the additional argument regarding omission of services were addressed in Anderson and Monroe. So I think this has all been well decided and resolved at this point. There was COVID treatment, unlike Jokinen, where the patient did not have COVID, and it was decided on a C8 basis. So there was no consideration of whether the pressure ulcer treatment was about lack of resources. So that's back at the trial court. And Skipper Baines, again, that was the assault case, which wasn't involving the treatment of COVID. So I think Warren decides this. So unless you have any questions, I'll leave it at that.
No questions at this time. Thank you, counsel. Anyone else?
Good afternoon, Your Honors. Russell Booker for Fairlane Senior Care and Rehab Center, LLC. Again, I think there's not much to say here other than what is in the brief. Despite the intervening case law that's come from the court, this case is still on all fours with Warren fully. The only difference for my client is that it is a nursing home and not a hospital. Nursing homes are expressly covered as facilities under the Act. This is all within the statutory timeframe. The plaintiff was being treated for COVID and rehabilitated for COVID at Fairlane. This was a C7 motion that was in effect treated under the C10 standard. We submitted ample evidence to the trial court, and the trial court had that when it made its ruling on our motion. So unless the panel has any questions.
Thank you.
Thank you, Your Honors.
You can send a memo to your buddies and say, hey, make sure you get the last or second to last case. We've worn them out by then.
Good afternoon, Your Honors. Andrew Malik on behalf of Defendant Prime Home Care. I will likewise be brief. As many of the, as we've stated, all of these facts fall under the framework in Warren. With respect to the specific facts of Prime Home Care, just to highlight on his intake summary, it does say for infectious disease, COVID-19, and that is also part of his treatment in his log notes and on his discharge summary as well, that there was treatment for COVID-19 and respiratory illness that he was being treated for. So we also believe that this case falls squarely within the framework in Warren, which also decided the issues regarding gross negligence and waiver of the issue of gross negligence and the void for vagueness argument as well. So unless there are any other questions.
All right, thank you, counsel.
Thank you.
Counsel?
Yeah, just very briefly.
I just wanted to go over some of the the reason why I believe that the line should be drawn is because of the significant damage that happened after admission of Fairlane and moving forward to Prime. The right buttock injury was roughly 9.5 centimeters by 8 centimeters. It ballooned at Fairlane to 15 by 20. And then being admitted to Prime, it went from a stage 3 to a stage 4, and it became infected, resulting in numerous debridements after Prime had taken care. So we believe that this case is important because that there was so much damage related after he was sort of released from that COVID cage that it warrants some sort of line drawn decision here. With that, thank you, Your Honor.
All right, thank you all. The matter will be submitted. Our final case of the day, counsel who have been waiting patiently. I think Mr. Simon all day.
Yes.
So thank you, sir. I honestly kicked around taking it out of order, but I thought, oh man, I'll have a.
If you only
revolution.
knew, because I was the number one on the docket, on the panel 1, so I've been here for 4 hours.
Yeah.
We
We
have
appreciate,
some treats in the back if you want some.
and we appreciate you and plaintiff's counsel and the work you do. So
I did all my begging on Friday.
this is 368-936 People v. Black. We have the privilege of having Mr. Simon before us on behalf of defendant appellant, as well as a standard 4 brief of Mr. Simon. And then we have the privilege of Ms. Cretu on behalf of the plaintiff appellee.
Thank you. And may it please the court, Jonathan Simon on behalf of Mr. Black. Let me deal with the issue about the motion in limine, because I know that it was of some concern because we have not been able to locate the order. In fact, the hearing for Mr. Black took place on one day, I believe it was August 10th of 22, something like that. And then there was a co-defendant, Mr. Daniels, and the argument was to resume the next day. Of course, Mr. Daniels' case ended up being dismissed, and so he, of course, did not have to appeal. That transcript was never ordered until most recently when I requested it, but have not received it. I have been in contact.
Is there a transcript?
Yes, the transcript of the motion as to Mr. Black was provided. And at the close of that hearing, Judge Cusick indicated that the matter would continue the following day when it was going to be raised as to Mr. Daniels. As I said, Mr. Daniels' case was dismissed. We do not have a transcript. I've requested it, but it has not been yet produced.
So it might have been transcribed under Mr. Daniel's case number as opposed to Mr. Black's case number, because they call both cases, but they could only record it underneath one, the way it works at Wayne County.
Understood, except in this case, the hearings were on separate days. And of course, because there was.
Defendants in court?
No, I believe that the attorney for Mr. Daniels, Mr. Nasser, was not present. He was to appear the following day. And although I have the register of actions for both dates, and both dates show only that on those dates, there was a hearing on a motion to quash. It says nothing about the motion in limine, which was filed by the prosecutor. At the preliminary examination, Mr. Black's attorney had asked the complainant, Mr. White, if he had any crimes involving theft or dishonesty. He said yes, and it ended right there. Counsel at the time, Ms. Al-Hawashi, who I believe is now with the Attorney General's office, she filed this motion in limine after determining that Mr. Daniels did have a conviction from a few years earlier for receiving or concealing stolen property. And we do have the arguments on the day of Mr. Black's hearing. We don't have the arguments from Mr. Daniels' hearing. However, review would be de novo. So I think, this court can proceed on the merits. And counsel has Ms. Cretu has responded on the merits. And I believe it's her understanding as well that the motion was granted for the prosecution. That's my understanding.
the 609 evidence.
Yes.
Okay.
And it's my understanding also from counsel for Mr. Black that the motion had been granted. In fact, at trial, he did not go into any impeachment evidence. And so we do believe it has been preserved, notwithstanding the lack of a ruling on the record or a written order.
Why is it dispositive?
Why is what?
Why is it dispositive that Judge Cusick, that it was a mistake, that it's a mistake that warrants either alone or in conjunction with everything else a new trial?
Well, credibility was certainly a strong issue here. In fact, it's also dealt with in the I think in the argument too as well, because Mr. White, I believe he pulled the video. He told people to leave. And so there was a lot of theory and speculation and cross-examination that perhaps he or those
He was the
associated.
guy that he did it.
Exactly.
Okay.
Or that he was somehow involved in it, in the death of the decedent. This person comes to his gambling party
Right.
at his fiance's salon after hours. Well, actually, the place hadn't even opened for business yet, so there were no hours, but it was at night. This gentleman who had a blood alcohol level of over 0.4.
Right. That was
Leaves,
remarkable.
comes,
0.46, I think.
Oh, I had a 0.688 and she was still walking.
0.688.
0.688.
0.51 was the highest ever, so.
She testified and had a 0.167 and testified beautifully. You couldn't even smell it.
Oh, my.
Yeah, I digress. Go ahead.
We all did this. Yeah. Sorry, we're all reliving our trial court days.
yes, I know, I understand. I've had a few recently, super drunk cases myself.
Wow.
As an attorney, of
Yeah,
course.
okay, sure. Yeah.
we knew that.
No, it's a friend of mine. I swear to.
So he says, I'll be right back. He comes back with a box full of cash, which under the circumstances, perhaps explains his blood alcohol level, I think explains his level of recklessness in that regard. But he, of course, is now the decedent in this case. And there's some question as to how and who caused his death, given the fact that there was video which was then removed by Mr. White. And
But Mr. White, and watching the video, and it's a pain because you can't like fast forward, and if you miss it, you're like done and you gotta watch the whole thing again. You could see Mr. White in the, okay, I'll call it the gambling room, and then like the ante room, right? The ante room is in the back, so you can only see it through a doorway. You can see right before it cuts out, Mr. Black playing at the table, and then he kind of disappears, like he walks toward the camera. Mr. White is, you can see him out in the ante room, and then the video cuts out. So I'm trying to figure out how Mr. White could be the person who cut off the video if he's actually in the video itself. It doesn't seem to me to be possible.
well, again, he's the host, so he
I know,
has
but
associates.
do you have any theory with respect to that? Because actually watching the video, he's out in the ante room. Mr. Black has gone toward the camera, toward wherever the camera is located, right? Because you see him walking toward the camera, but he's off camera. But you literally see Mr. White on camera. And then
When the camera shuts
when the
off.
camera shuts off. So I'm trying to figure out what the theory is that you and Mr. Black have as to how Mr. White could be in the videos and be the one who pulled the plug out.
Well, again, it's his house. He knows the setup. He knows where the camera, the recorder is, where the cameras are located. And so it seems reasonable to believe that those in his associates of him would have that information and would be able to accomplish that task. Certainly more so than Mr. Black, who is a guest at this gambling establishment.
So it's not just that maybe he's the person who literally, quote, pulled the plug, but maybe he had a Confederate that pulled the plug and then he committed the homicide.
Yeah, or perhaps even by remote control, even if he's walking toward it, I don't know that we can see his hands.
But he's not walking toward, he's walking like across I think from stage right to stage left, as you see him crossing in the anteroom, and he's not pointing at the camera. You don't see his hands up pointing back toward where the camera is, nothing. He's like shushing people. It looks like he's trying to usher people out the door. It's time to go.
Yeah, and you don't need to point a remote control at an object to have the remote control it.
My TV, you do.
Mine, sometimes I'll be pointing the opposite direction,
Okay.
or
You have a
maybe
better
just,
TV than I do.
or maybe
That's
just
okay,
better
Mrs.
remote
Stark.
controllers. There you go. But, and then, this all kind of ties into argument two as well, which was the closing argument, because credibility is such a major factor in this case, because my client, is later found with cash, and there's some blood of the complainant and some blood of my client, blood of the complainant on the cash. And he says, well, no, I dropped my stuff, and when this killing happened, but I picked it up and got out of there. But the people are trying to suggest that, well, this is the decedent's cash because that's why the decedent's blood is on it. And in the closing arguments, the prosecutors are arguing, well, you can tell these people are afraid of Mr. Black. They wouldn't look at Mr. Black, but there's absolutely no evidence to substantiate that claim. There's nothing to show that Mr. Black has caused any fear, any threats, anybody acting on his behalf has caused them to be afraid of him. And yet that is simply thrown out there by the prosecutor. And I call it misconduct. You may call it error, but the deal is to try to paint Mr. Black as this horrible person who murdered this drunk man for his cash. And to me, I think that given the inferences which were suggested in closing arguments, together with the lack of the ability to impeach Mr. White as to his prior conviction, we have a situation where my client has really been hampered in his ability to present a defense. And so we believe that given those two perhaps in concert, that this is not a fair trial, and I think that Mr. Black deserves better, and I ask that he receive a new trial.
All right, thank you.
Thank you.
All right, appreciate it. You have time for rebuttal if you like.
Hey, please, the court, Mary Casey Cretu, P72485 on behalf of the people, and I don't have anything more to add to my brief, other than just to respond to a couple of things counsel made. There's absolutely no evidence to support this theory that Anthony White committed this crime. All of the evidence is in support of defendant's guilt. It's pure speculation to claim that he actually perpetrated this. And he explained, on the record why he felt he wanted to come forward because of he owed it to the victim who didn't deserve this because he had hosted this illegal gambling party. And it was this is such a sad, sad crime that it was almost like it could be a screenplay for a movie because it's horrible. But there's no evidence in support of the fact that, or the theory that Anthony White committed this. And in terms of the defendant's third argument that the Anthony White's conviction should have been admissible, things might be different if there was not also another eyewitness to this crime who testified. So Cooper Black's testimony, which is consistent with Anthony White's testimony on the most important parts, because they were viewing the crime from different vantage points. So that explains some of their differences. But for the big parts, they were consistent. And I just wanted to point that out for the court. And I also stand for questions.
Should the evidence of conviction been admitted?
Repeat that?
Should the
Please.
evidence of the conviction, the criminal falsity evidence, should that have been admitted by the trial court?
I don't think so, because it's not a crime of dishonesty or like it wasn't perjury. It was a theft crime.
Right.
Almost 10 years had passed. We were getting close to
Yeah,
the 10
right.
years.
No, if it's 10, if it's over 10, it obviously
Right,
can't come in.
obviously.
But
So that amount of time within that 10 years is what you look at. And then is it probative? Is it going to add to the credibility? Anthony White's credibility was tested
right.
vehemently by defense counsel at trial in a more important way in this case for his inconsistent statements about this crime. This court has held that crimes of theft, not dishonesty, are low probative value towards credibility. So no, I don't think it should have been admitted. It could have been, but it wasn't an abuse of discretion for the trial judge to conclude that. No, it was well within the range of principled outcome.
Okay.
Was there anything in the standard 4 brief that you wanted to talk about?
No.
Oh, sorry. All right. I'm just trying to figure out, do you have any idea, because I think Mr. Simon already talked about this, why we couldn't get that?
So I think here's what happened, and Mr. Simon did kind of explain it, but because co-defendant's case was dismissed, transcripts from that case were never produced because he didn't appeal it because it was dismissed and we didn't appeal it.
But you'd hang on to those things.
Oh, they're available. They're going to be produced, but they had to be ordered first. And Mr. Simon didn't know that he had to order the co-defendant's transcripts because the Register of Actions don't say that this defendant had a hearing on that same day. But based on Judge Cusick's statement at when we argued this issue below, he said he was going to put it over for co-defendant, co-counsel, or co-defendant's attorney to weigh in on the issue. And that's why it was heard the next day. I think that that's when it was ruled on. The motion in limine.
But there was no order in the register. of
No
Actions.
order, and there's no Register of Actions entry, and that is most likely, I would imagine, a clerical error. But I don't have any reason, and I did check our file for the order as well, multiple times, and I didn't come across it, unfortunately. But I have no reason to believe that Judge Cusick didn't simply grant the motion in limine.
And do you know what his practice typically is for
He's-
preparation of orders subject after those kind of hearings?
I
Does he do it or
find
does
him,
counsel do it?
I think his judicial attorney, Janet, would do that, and she's very good about, she's been there a long time, so I was surprised that the order wasn't available.
Okay, that's all I've got.
Thank you.
Thank you.
Thank you.
Couple things.
Simon.
First of all, Mr. White's conviction was June 5th, 2015. So at the time of the August 2023 trial, it was barely 8 years old. It was within the 10-year
No
window.
question. Right.
Secondly, I did talk to Janet Walters. She is Judge Cusick's judicial attorney. And surprisingly, she told me that Judge Cusick doesn't even hear motions in limine until the trial date. So she was surprised that it was heard at the time of the motion to quash. She referred me to the trial and I reviewed again all the preliminary matters at the trial, and it did not come up at that time at all.
We all agree that he denied the motion to quash.
No, he denied, yes, the motion.
He
to
wouldn't
quash.
let the defense use it for.
Well, no, what he granted was the prosecutor's motion in limine to suppress Mr. White's
Got it. Sorry.
prior conviction. And we do believe that it was a crime involving dishonesty.
Okay. Oh, I see. All right. And not just that. Okay. Good. Anything else?
No, thank you very
All
much.
right. Thank you both. And gosh, thank you for your patience and
Yes, thank you.
your willingness to serve in these cases. They're
Appreciate it
important for everybody.
very much.
Thank you. All right, that matter is submitted. That completes panel 8's, whatever panel number we are.
Number 2.
Number 2,
So panel
our
number
case
2.
call for the month of November. Thank you. We are in recess.